What is the predicament in mentioning after giving a notice?
Next notice,
Mulad.
I will next notice I'll serve.
Mulad.
That's not an issue. But the issue is not more so with my learned friend. Issue is with the file. That is why. And here is not the letter also I have, which I have written to the registrar. Please trace the file. Because the file cannot be traced. That is where the main problem.
But a new file, 9/52/2024.
This is 2024.
Give me the letter.
Letter to the registrar.
May I just, after your minor...
I'll make it. Let me go through this.
I've also said that where it is supposed to be lying.
Yes, sir.
Firstly, my lord, the order was on 8th of February 2024. That on 12th of September 2024, your lordship has noted their presence and not directed the matter to appear. 21st November 2024, specific of order of your lordship that if they cannot bring the stay order, your lordship will proceed with the contempt applications. Lord, in the previous case, the notice even served, the copy was served, not even copy of the MAT and the stay application has been served upon us. There is single slightest attempt on part of the respondents to make the hearing of the appeal. Because once the appeal will be listed, then where's the service? The court will say they did the matter in this way. This is not the welfare state only denying the benefits of minimum wages. Right, my lord.
I believe this order will help you also.
Yes.
Yes,
And
definitely,
only
my lord.
this, can I not put a photocopy of that letter to the?
ওইটা না যেটা বললাম না হ্যান্ড ওভারে ফটোকপি অফ দি লেটার অরিজিনালটা ফেরত দিয়ে দাও লেটারটা দিয়ে দাও ফটোকপি অফ দি লেটার
But I have deepest respect. Kindly do not make me understand.
No, no.
Mr. Bell. The state is
happens.
denying the minimum wages.
My lord, item 4, I'm for the petitioner, my lord. This is an application for a substitution of the deceased, of the legal heirs of the deceased writ petitioner, my lord. On the last occasion, my lordship had directed me to serve a notice on the learned advocate appearing for the state respondents. I've served the notice, my lord.
who will be substituted
My lord, the legal heirs who are mentioned in paragraph 6, page 8 of the CAN application.
it is with when he has died
He has expired, my lord, on 14th of December 2023, my lord. That I have stated at paragraph 5,
hmm.
page 8.
Hmm.
And the death certificate is also annexed, my lord, as annexure P3, my lord. That is at my
It
lord.
is within time
Yes, my lord, within time. It was filed on, my lord,
আসুন
My lord, I am appealing for the respondent. Your lordship remembers the matter, their intention is not appealing because they have filed a review application.
Yes.
Now, my lord, kindly see their conduct. They have in the trial court, your lordship has been pleased to allow the amendment application, my lord, the amendment application which was allowed by the trial court. They filed a revision. Your lordship has been pleased to dismiss the.
It is CO.
Yes.
Oh, review against the CO.
Yes, they have filed. Now already, Malak kindly see, they have filed the additional written statement and PW1.
Give me a second. Give me a
Yes,
second.
and PW1 has been cross-examined.
Instant revision is devoid of any merit on perusal as a trial court. Say amendment is sought for. What is the matter about? I forgot.
Matter is, my lord, one amendment was sought for.
We want to the
I
copy
will
of the
very-
plain.
it is a-
Just a minute, Mr. Mitru, just a minute, sir. Oh, prayer for amendment was allowed. Very
Yes.
good. Then what happened, sir, in the trial court?
My lord, against that they preferred the revision, it was dismissed. Against that they preferred.
So amendment stands.
Amendment stands, they have already filed additional written statement and PW1, my client, while I filed the examination in chief, he was cross-examined. I am giving the copy of the order.
Very good. Keep it.
My lord, I will be, my lord, kindly not misunderstood me, I will be paying my lord a cost, my lord, on behalf of my client. Because unnecessarily, for filing of review, they have to engage.
None appears on behalf of the petitioner. Review petitioner.
Your lordship may take this copy on your lordship.
Very
my
good.
lord, if they require.
Yes. Mr. Good, very good.
My lord, only 1 minute, my lord. My lord,
Please,
it,
please,
my lord, it cannot be dismissed.
Sir, this is an
because-
equitable. This is an equitable call.
My lord, but the thing is that I have placed in the
Mr.
constitution
So dismiss
all
for
the-
default. Let them, if they choose, they will come. আরেকটা লিখে নিন। I am doing equitable. Learned trial. Call the next matter.
His Lordship, 6 is concerned, Lordship. We are appealing for the writ petition is matter, Lordship. Yes, Lordship, this matter is very old one, Lordship. This matter is of Lordship 2010. Lordship, what happened, Lordship, is aspect of settlement which was, because
Yes,
this,
yes, I
yes,
know.
its matter
No
was,
settlement has
no,
been
Lordship,
earlier.
Lordship, because
Proceed with the writ petition.
His Lordship, just one thing, Lordship,
On the last occasion, who appeared on behalf of your client?
His Lordship, His Lordship, just one small submission, Lordship, this matter requires to be heard. Lordship, would it be Lordship's pleasure, Lordship, to fix it 2 weeks after vacation, Lordship?
You are for the,
We are for the petitioner, Lordship. We are for the petitioner, Lordship, because they had claimed for
but your
more than
client is eagerly waiting at the back.
Lordship.
It is the same matter, বললেন?
Yes, Lordship.
Then why are you
Lordship,
seeking time?
Lordship, because Lordship, our learned senior is on legs, Lordship. Lordship, this is a thing, this is a very old
You
matter.
know your client knows is your submission.
Lordship, have
Your
come-
client knows
No,
your
Lordship,
submission.
Lordship, have come direct. Lordship, we are not on record, Lordship. Lordship, this is person. Lordship, we have been engaged. My learned senior, Mr. Ranjode, he's been engaged in this matter. Lordship, I'm praying for Lordship 2 weeks after vacation. And the matter is ready for hearing.
But
Lordship,
your
matter
client
request to-
was personally insisting this court to take up the matter and he was seeking time.
Lordship, this is what instructions have received, Lordship.
Time, my lord.
From a learned senior. Lordship, because this matter requires hearing, Lordship, because we have presently my learned senior.
No, then you have to say to your client that I am seeking your time. Then I will grant you time. Otherwise, not.
Lordship, I'm praying.
Because otherwise, he will bear an impression that the court is not interested to hear out the matter.
for
Please say.
Lordship, yes, Lordship.
No, you please say. You have to grant. I will not grant time.
No, I'm making a prayer before you, Lordship.
See, the gentleman with folded hand on the last occasion requested me to do justice. I'm here to do justice.
Lordship,
Either
in
in
that
favor of
event,
your
Lordship,
client or in against.
yes, Lordship, in that
But
event,
I must ensure that your client must know
Yes,
that
Lordship,
you are seeking time.
yes, Lordship,
Otherwise, I will not grant
Lordship,
your
in
time.
that event, Lordship, may Lordship kindly grants a passover, Lordship, because Lordship,
Very good. Your court will not take the blame. You have
No,
to take the blame.
absolutely, Lordship. Lordship, I'm just praying.
He is
Lord-
waiting. I know him personally. On the last occasion, rather on the last 2 occasions with folded hand, he practically cried. Why should I grant you time?
Your Lordship, I'll just have a word.
Yes,
Lordship,
Passover.
Yes.
Passover till 2 p.m. No, 2 p.m. now. 11:30 p.m. এটা item number কত?
Can it be Lordship 12:30 subject to Lordship's approval?
12
Lordship?
o'clock, I have some fixed matter, no?
It can be 12 then, Lordship, subject to
12 o'clock, I have a fixed matter, sir. Very good, 12:30.
12, Lordship.
You listen. You tell your client, you know him? The gentleman
Lordship,
with
we are
yellow
coming to-
color.
Oh.
সে যে ম্যাটারটা 12:30টায় নেওয়া হবে। আপনার উকিল বাবু টাইম চাইছেন তো আমি কি করব?
Company. Lordship is not for the company, Lordship. We are for the company. It's for the Lordship workman, I think. Responded.
আপনার উকিল বাবু কোথায়?
His lawyer is not here only, Lordship.
So why are you happy standing in the
Lordship,
petitioner?
I'm for the, because we are the petition in this matter. Lordship, because petition is the company. The petition is the company, Lordship.
আপনার উকিল বাবু কোথায়?
Yes, that's the,
আমার একটু আমার উকিল আসলে একটু দাঁড়িয়ে কথা
উনি তো সময় চাইছিলেন।
হ্যাঁ?
উনি তো সময় চাইছিলেন।
না 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 না
12:30টায় আসুন।
আমার
12:30 করলেন, আসতে বলো 12:30। এই করলেন, বলো 12:30, টাইম যায়নি।
Is also my learned senior also.
12:30, 12:30,
Also my learned senior.
come at 12:30, call the next matter.
Already,
12:30, no sir, no time,
no, I am not praying for any time, Lordship.
12:30.
That he has been represented through an advocate, that's why I'm
If
telling.
he says that otherwise,
No, I don't have.
12:30. এই উনার উকিলবাবুকে বলে দিন 12:30টার সময় যেন থাকে কোর্টে।
ঠিক।
ভদ্রমহিলাকে বলে
Your
দিন।
Lordship was kind enough to send for mediation. He asked for
Witness had failed.
1.5 crores, and as for our calculation, it is within 1 lakh.
বলুন আপনার উকিলবাবুকে বলতে বলো কল্যাণ যে 12:30টার সময় যেন মামলা কল হবে, যেন থাকেন।
তোমার কি?
Come at 12:30 sir.
Yes.
কিছুক্ষণ চলার কথা যদি other side থাকে।
Who is your other side sir?
They state Mr.
On the last occasion also. তন্ময় চক্রবর্তী and Mr. সপ্তক সান্যাল। Very good.
My lord, I am told by state's advocate, Mr. Thomas Chakraborty, that he is on his break in court number 5. Because he kindly keeps in the Passover.
Passover. কত নম্বর item? Item 8 and 7. Passover.
Lordship, in item number 10, I appear on behalf of the petitioner. Item number 9 is the revisional application.
Item number 9 is my application.
Expeditious disposal of the execution proceedings. Lordship, this has been tagged together, which was indicated on the last occasion. Now everything can be taken up together for hearing, my lord.
Lordship will kindly take
Give
9
me a
because
second.
my learned friend has nothing to say in 9.
No, but definitely I do have everything to say in 9.
Very well,
because
then
now they are proceeding
Since
in
it's my
execution.
application, let me start, then my learned friend will say.
Who is for the read petition?
Lordship, I am. This is my
I am for the
application.
writ petitions. I am for the writ petitioner in item number
10.
10.
In 9, I am the petitioner.
That's a criminal revision.
No, so far as item number 10, there is a read petitioner. Who is the read? who is
I
the-
am the writ petitioner.
Very good. Then you stay there. And so far as item number 10 is concerned,
Item number 10, my learned friend is.
the writ
Item
petition,
number
my lord.
9, I am the petitioner. Lordship, if I may just indicate what item number 9 is.
CRR.
Item number 9, it has been released and it has been assigned before your lordship.
That I've seen yesterday.
Yes. Lordship, what it actually is execution proceedings after determination under section 33C is sent before the judicial magistrate. The judicial magistrate, the proceedings have been pending for a really long time, since 2018. Lordship, 6 years the matter has been pending. So this is only for expeditious disposal of the proceedings before the judicial magistrate. If your lordship kindly takes up item number 9.
And the order which is under execution is under challenge in this read petition.
No, my lord.
Yes.
No.
Yes.
What my
Lordship, may
learned friend
kindly-
is challenging
Lordship,
is
may
an
kindly take
application
up page
under
14
section
of their
33(2)B.
Lordship, may kindly take
Lordship,
up page
both of us
14
can't
their-
address. If my learned friend wants to place my
No,
application,
that
let
is
him
not a
place.
correct submission. Of course.
One after another. Let me understand whether why it has been tagged together.
I'll tell your lordship why. What happened was, workmen were dismissed. After dismissal, they filed an application under section 33(2)B for approval of the tribunal for approving the dismissal
Before the commissioner,
before the tribunal,
before the
Lordship,
tribunal.
industrial tribunal. Lordship, what happened is their application was rejected. That rejection is what is under challenge in item number 10 by my learned friend. Lordship, once the termination is held to be bad, the workman is entitled to be reinstated along with back wages. The company doesn't do it. So we file an application under 33C2 for determination of our dues. A determination
Before which court?
before the tribunal,
Tribunal, very
the
good.
labor court. Lordship, what happens is in 33C2, a determination is made holding that I'm entitled to 20 lakhs. Now it is again,
That is subject matter of execution before the judicial magistrate.
that order is like a certificate which is before, like an execution proceedings before the judicial magistrate. Because under the West Bengal Amendment to the Industrial Disputes Act, the matter has to be sent to the judicial magistrate. Lordship, that matter has been pending since 2018.
Very good. I understand. You have filed a criminal CRR for expeditious disposal of that matter. And what is the writ petition about?
My learned friend's writ petition is challenging the 33(2)(b) application where they had taken the approval of the tribunal to confirm the dismissal of the workman,
Which was dismissed.
which was dismissed.
So after dismissal order, you preferred an application for quantification of the compensation. That has been done. And that is thought to be executed by the intervention of the judicial magistrate.
Lordship.
Then, for the sake of argument, in the event if I allow the writ petition, automatically execution goes, and if I dismiss the writ petition, execution will proceed.
Lordship, perhaps this question would have come up had they not admitted to the order. Lordship, they have admitted to the order that 33(2)(b).
Very good. We have to hear this matter. Let us start. Yes, start your case.
Lordship, will let them start.
I'll hear.
Very well, Your Lordship.
ওটা উইথ হয়ে যাবে। হ্যাঁ।
Lordship may kindly take up the order, the last order which was passed in the writ petition 5573, order dated 21/11/2020.
Just a minute. And in the CRR, you are the opposite party number.
I must be the opposite party number 2, because first it would be the state.
Opposite party number 2. Your good name, sir?
Shokabdur Roy, my lord.
Yes.
Lordship, if I may kindly indicate. Lordship may kindly see, Lordship has taken up the writ petition or the criminal revision? Writ petition.
You say which I will take.
I will kindly indicate. Lordship, the first.
The writ petition has been filed by you, no?
Yes.
What is your prayer?
Lordship, my prayer would be.
চেঁচামেচি হচ্ছে? ঢুকে বাইরে বলে এই বলে এসো চেঁচামেচি বন্ধ করতে। What is your prayer?
My lord, my prayer is plain and simple, lordship. If I place the impugned order, lordship, I am simply praying for setting aside of the impugned order passed by the Labour Tribunal. Now, lordship, before that, I had filed the petition way back in 2016.
You are the statesman limited.
Yes. Thereafter, there was a direction for them to file their affidavit in opposition. And it is only now that they have started filing their affidavit in opposition. Lordship, may kindly take up the last order which was passed by my lord on 21st of November 2024.
21st of November.
2024, page 2. Paragraph 4. It reads, affidavit in opposition, if there be any, is to be filed within 2 weeks. Hence, affidavit in reply 1 week thereafter. My lord, the last affidavit which we have received is 1 day back. Day before yesterday is the last affidavit that we have received. Now,
Reply.
Opposition. We were to file reply. Now, if they are filing their opposition in piecemeal. When they say that they are representing, maybe they are taking different stand. I do not know. I have to go through all of them and file my comprehensive reply. Now, my lord, this.
So where is your affidavit in opposition? You have filed.
Only yesterday they had filed in court.
Have you filed your affidavit in opposition?
Only yesterday.
I believe it has been filed.
Only yesterday. My learned senior friend was not there. His junior was there on the last occasion when it was taken up yesterday. Now I am to file my reply.
Affidavit of Ashok Kumar Pandey. Has your lordship got the affidavit of Ashok Kumar Pandey? Affidavit in opposition?
You are not sure that whether you have filed or not.
It's been filed, my lord. It's been filed. My learned friend also agrees that it has been filed.
No, I do not know whether it has been filed. I said I have received. I have received, and my learned senior friend was not there on the
Give me a
previous
second.
occasion.
Give me a second.
His junior had I suppose had filed it
Affidavit
on
of
the
competency.
yesterday only.
ওকালতনামা
না আর দুটো আজকে ফাইল করবে এখনো ফাইলই হয় My lord, I am told by the learned junior, the advocate on record of the respondent that they are yet to file their affidavit in opposition.
That is
Can the hearing be continued in piecemeal?
এই ফাইলটা দাও তো বাবু নাকি check it.
Because lordship, I need to file a reply, comprehensive reply to all their oppositions.
Lordship, the first document is the affidavit in opposition. Your lordship will also find my learned friend says it is yesterday.
No, that is what he submitted.
It's on 5th November 2024.
5th November.
My learned friend, if it's an elaborate argument to take time, we can take time.
No.
I do not throw incorrect aspects to the dust.
Where is the affidavit in opposition?
Lordship, the first document is the affidavit in opposition on behalf of Ashok Kumar Pandey.
Lordship, to this date, if I am not wrong, I think I have received only 2 oppositions. Let them clarify. On behalf of respondent number 4 and 3.
The substitution.
Yeah.
No, they have filed their affidavit in opposition.
Only for 2. They are representing more than 2 respondents.
3.
এই কল্যাণ এত মোটা হয়ে গেছে না পেপে অর্ডার বুকটা আলাদা করি না তো নেমেই যাচ্ছে কাজ করাই যাচ্ছে না you will use any other affidavit of opposition?
Lordship, it's an identical. I will tell your lordship why the delay is there. Day before yesterday, an order was passed by the appeal court in this matter. We are also including that order. The conduct of my learned friend has been taken into
Be
account.
that as it may, whether you intend to file any other affidavit of
Lordship,
opposition?
we have also served. We will file it in the course. I believe because of the fight, my clerk has not come in. He will come in. I will hand over the other affidavits before your lordship. My learned friend has already been served. They have also been served on
How
behalf
much
of-
time? How much time will require to file the petition of opposition?
Lordship, give me 20 minutes. He will come. I will tell your Lordship who I have filed the affidavit on opposition on behalf of. The first affidavit is on behalf of respondent number 3 has been served,
That has been filed.
and served on the other side. I have filed on behalf of respondent number 4, served on the other side.
That is not here.
Lordship, it will come. Just give me 5 minutes, it will come. It's on its way, it will come. We will hand over to your Lordship. On behalf of respondent number 7 also we have filed. On behalf of respondent number 10 also we have filed.
That we have not received. 7 and 10.
No,
That's to take now.
You have to complete the file.
We have to complete the pleadings, my lord. That is
That too.
because I need to file a reply.
The question of completing the pleadings, I will place before your Lordship that all have been served upon them. Chithi dao. Unfortunate. Kindly see all the letters where it records that they have received it.
When?
Lordship, the first is on 12th November. The second one is on 28th November.
28th November.
And
The order was
on
of
17th December.
Also. So I will not
You
get an
just file.
opportunity to file my petition.
No, that I don't know. You file the affidavit of opposition.
বসে আছো এখানে অরিজিনাল গুলো নিয়ে ফাইল করছো না
নিজের ব্যাগে ঢুকিয়ে নিয়ে বসে আছেন কি লোকরা।
Lordship, all that I was praying, Lordship may please grant me an opportunity to use a reply and we shall come back because everything now, if the pleadings are complete, we can start the hearing.
এই আসুন তো ভাই, এইটা সেম হবে, এই কনস্ট্রাক্টরই হবে। is your answer is here.
May this matter be taken up action now.
What is your item number?
7, my lord, your lordship has passed.
Your other side is here.
No, my lord, can't find him, my lord. The state, my lord, the report as directed by this court has already been
দেখি
filed.
পাসওয়ার্ড
It
ম্যাটার
is-
কি আছে? What is the matter about?
My lord, it is concerning the excise license, which was cancelled for non-payment of installment. Though the installment was,
Give me a second. Which order is impugned, sir?
my lord, the 3 orders,
11-8, 9-4 and 14-7.
my lord, my lord, the cancellation order, that is, my lord, yeah,
Show me the orders.
page 51, 52 and 53.
Page 51, 52 and 53.
These are the 3 orders which is under challenge.
Just a minute.
My lord, may I hand over a short list of dates I have
Just a
prepared?
minute, sir. I will take. I will definitely take.
Hmm.
So your license has been cancelled.
Yes. My lord, by
It
3,
is a warehouse.
my lord, there are 3 licenses. All the 3 licenses, one foreign liquor op shop, second, my lord, warehouse, and third is trade.
You serve notice, then come.
My lord,
A report has come.
my lord?
A report has come.
Yes, yes. Lord, the court, this honorable court was of the view that if the entire amount has been liquidated, then the impugned order cannot be sustained because it was cancelled on the ground of default in payment of installment that was condoned by this honorable court.
You don't have prima facie, you don't have a very good case, sir.
Lord, I'll satisfy your lordship on that.
Very good. Serve notice.
Lord, notices were on several occasions, my lord, they appear.
Is the state as a or the Union of
State.
India?
State. Your lordship, kindly see the several orders passed by your lordship.
Absolutely. Mr. Tonoy Chakraborty and Mr. Shoptok Channel appeared.
Yes. On last several occasions, they took time on one ground or the other.
আসুন
Okay. 11, my lord. I am for the petitioner. I am led by Mr. Kaptan Subasu. My lord, the matter relating to very interesting point involved in this matter.
You say you are ready or not?
My lord, ready.
My lord,
Full ready.
My lord, learned advocate general is
Lord,
here.
that is, my lord, usual. That is usual. Please. That is usual prayer of the learned on behalf of the learned advocate general. My lord, lordship, kindly have a peruse the all orders passed by the different honorable benches. That every time, my lord, they prayed for time. Every time. Matter is very simple. My lord, first I, my lord, place my case.
You are for the private respondent?
No. Diga development.
I can speak for it. But I appear for the requiring body, the Diga Shankarpur Development Authority. The land has been acquisitioned by the acquiring body, the state government.
Here the respondent is Union of India, I find.
And I will, my lord, I will take those points at my submission that whether Union of India is at all a necessary party. Well, my learned friend will let me submit.
Is it a wrong type?
No, my lord, it has always been the first party of the Union of India. No, my lord, it has always been the first party of the Union of India. It has been served upon us also like that. Number one. Number two, lordship will possibly find that there are three private respondents.
No, yeah, the state of West Bengal, is no Union of India.
No, the party state. It has from the very beginning, possibly it has been wrongly typed in the cost title as versus Union of India. So therefore, the union is in no way.
In my petition, always state of West Bengal, page 2.
Dekhe now.
ইউনিয়ন ইজ নট এ পার্টি, তোর ফার্স্ট ইয়াতে ভুল করে ফার্স্ট ইয়াতে ইউনিয়ন
আরে রয়েছে তো, দেখো না এখানে 2 নম্বর পেজে স্টেট অফ ওয়েস্ট বেঙ্গল, আমার কোনো ভুল নেই। স্টেট অফ ওয়েস্ট বেঙ্গল আমার কোনো ভুল নেই।
not happy for the requiring body, the Diga Shankarpur Development Authority.
That is respond number
Respond number 4, 4 and 5.
4 and 5.
My lord,
I am for the added
yeah. My lord,
I am for the
My learned friend is absolutely agitated.
not agitated.
Lordship has,
Normal
You are
body.
adding as
I
per
am
number.
my lord, I think, my lord, with all due respect, my lord, I think I should retire from this brief. Because this is not the way I've learned them, my learned friend is speaking to me. It's like my younger brother, my lord. He'll allow me to speak.
You are appearing on behalf of
added respondent, my lord.
Belagaria Central Cooperative Bank.
My lord, may I still, may I just indicate in 1 second? Not the merits of the matter. My lord, the state acquired it, handed over to me as the requiring body.
understand. That
My
is
lord,
requiring body.
I have developed the body, my lord, that is, and handed over to the private respondent. That is where the private respondents come in. That is the point.
What is your prayer? Let me see.
Yes, and will kindly take the prayer in the
Illegal digging. Exchange of evidence are complete. Then where is the difficulty?
No.
So where is the difficulty, sir?
Read by my lord, Learned Advocate General, my lord. That's why, my lord.
There is no other advocate in the state panel.
Yes.
Advocate General remains very busy in other matters, very serious matters. No other state advocate is there.
I have to argue that this comes whenever they don't allow.
Exchange of evidence are complete.
My lord, I will be taking, whenever lordship allows me, I will be taking the point that possibly on merits and on, my lord, maintainability, the writ petition is not maintainable.
Yes, my lord, everything will be discussed.
Yes. No
My
problem.
lord, one by one. If my learned senior friend first will argue, then he will argue.
No. I will not argue. Let him place his case whenever lordship allows me, then I will.
His point issue, my lord already decided, my lord, on matters, my lord. I am appearing on behalf of the, my lord,
And then you
the
have to
respondent, my lord. No, my lord.
But
No.
then you will have to argue.
The state has filed an affidavit in opposition.
My lord, written notes of argument also, my lord, filed by the state, my lord.
Affidavit in opposition on behalf of the land acquisition collector Tomlu.
My lord.
This is your affidavit in
My
opposition.
lord.
Sir, start with the hearing.
My lord, when the petitioner filed this writ petition, that time, the petitioner prayer A, Lord, kind of look into page 11. A writ in the nature of mandama commending the respondent authority, especially the respondent number 5. 5 means Diga Konkorpur Development Authority to take immediate steps to stop illegal digging and on the land belonging to the petitioner. My lord, this is a hotel, and my lord, page 15, the Bitcoin Kavala Doli.
Your prayer is respondent authorities by respondent 5
Especially
take immediate steps of illegal digging. Who is the respondent number 5, sir?
but Diga Konkorpur Development Authority.
That is the requiring body.
Diga Konkorpur Development Authority.
Yes.
Respondent number 5.
Yes.
Then kindly come to page 15.
No, sir. Sir, the executive officer who is a functionary of Diga Samanity.
My lord.
Now, page.
Page 15 onward, my lord, the deed of conveyance. My lord, kindly come to deed of conveyance. The Hemanta Kumar Mishra, Creta, page 16. 15 Hotel Private Limited Pokhe Managing Director Hemanta Kumar Mishra. Vikreta Kanailal Kaur. My lord, নিম্নে তথ্যলি বর্ণিত সম্পত্তি, my lord, that dolill was executed on 13th October 2009. Page 15. Additional register subdivision.
So it is the deed of conveyance in favor of the writ petitioner.
Hemanta Kumar Mishra by Kanailal Kaur, the recital নিম্নের সেকেন্ড প্যারাগ্রাফ নিম্নের তফসিল বর্ণিত দাগের সম্পত্তি যা গত ইংরাজি 23/6/1994 তারিখে রামনগর সাব রেজিস্ট্রি অফিসে 2908 নম্বর রেজিস্ট্রিযুক্ত কমলাক্রমে মেদিনীপুর জেলার কোতোয়ালি থানার আবাস সাকিনের গুণধর পূর্বী বিক্রেতার নিকট হইতে খরিদা যত কর্তৃয় ভোগদখলি সম্পত্তি হইতেছে তা অত্র কমলার বিষয়যুক্ত সম্পত্তি হইতেছে।
So we'll abide by the schedule.
Yes, my lord. Then my lord, kindly come to page 80. My lord, page 19. My lord, 1800/2208.
So your
bias down. 1800/2208.
page number 18.
Page number 19. My lord,
মধ্যে সাবে
এলার দাগ 1979।
just a minute, sir. What I am on, no, Mr. Chatterjee, no?
Yes,
So far as জমির মধ্যে come to page number 18.
80.
জেলা পূর্বমুখ সাজান সাজ 1.34 টাকা জমি জমা মধ্যে সাবেক 1800, this is called বাটা দাগ,
My lord, বাটা দাগ সাবেক।
সাবেক 1800/2160. You got 20 decimal of land.
My lord.
Am I correct?
Yes, my lord.
Then in the same, no, in another bata dag 1800/2208, you got 11 decimal.
My lord. Two, my
So-
lord, my lord, kindly, my lord, note down two, my lord, dark number. Alert plot number 1978 and 1979 corresponding to
Hal.
Hal. Alert plot number 1978
Yes.
and 1979. Hal dark number.
There is a LR plot.
Alert plot number. And RF plot number 1800/2160 corresponding. Got it, my lord? 1800, page 18. 1800/2160.
So which one is relevant?
But not the, my lord, first, my lord, alert plot number 1978, 1978, and alert plot number 1979, corresponding correct dark number.
I understand, sir.
My lord. Then, my lord, kindly come to, my lord, page 25. After purchasing the land, every citizen, my lord, mutated the land in the era record of right.
Absolutely.
Page 25. 15 Hotel Private Limited পক্ষে হেমন্ত মিশ্র। And my lord, দাগ নম্বর 1978, 1979, জমির শ্রেণী পুকুর পার পুকুর। দাগের মধ্যে অর্থপত্রের জমির অংশের পরিমাণ 0.07 হেক্টর, 0.13 হেক্টর। That is এলার পর্চা, হাল পর্চা।
1978 and 1979. Your share is 0.8618. অর্থ সত্ত্বের জমির অংশের your share is 0.2 acre.
দাগের মোট পরিমাণ 0.20, রাইট হ্যান্ড সাইড, মাই লর্ড। দাগের মধ্যে অর্থতত্ত্ব জমির অংশের পরিমাণ প্রথমটা হচ্ছে 0.07 and 0.13। মোট পরিমাণ 0.20, দুটো দাগ মিলিয়ে 1978 and 1979।
So in the LR record,
My name has been
your
recorded.
name has been recorded.
Recorded.
Very good.
Then, my lord, my hotel is my lord running, no problem.
In this plot, in 1978 and 1979.
My lord,
Very good.
But adjustment plot. Thereafter, when I filed the writ petition, my lord, this honorable court directed to file the opposition and reply.
No,
Every opposition.
no, just tell me. You have showed me the deed of conveyance.
My lord,
By virtue of the said deed of conveyance,
muted.
you have mutated them. Your name has been recorded in the LR plot.
My lord.
Then what happened?
What happened? Diga Comfortable Development Authority, my lord, they are trying to encroach these two plots. And then I filed 144, thereafter writ petition.
Very good.
This honorable court directed my lord, respondent authorities file opposition and also directed me to file reply. Now, my lord, kindly come to evidence of opposition.
So according to you, they have made they are making an attempt to encroach your property
For the reason I filed
and digging the earth. Very good.
very simple writ petition, 2000 writ petition, my lord, for one file.
It may be simple to you, but not to me.
Thereafter, my lord,
What
at
you
the time of
opposition by
the state.
that
and
is
also
respond number
by respond number 4 and 5.
respond number 5.
4 and 5. Opposition,
Sujan Dotto.
my lord. Well, that opposition,
This is the requiring body's
my
opposition.
lord, according to them.
Just a minute. Affidavit opposition of the requiring body. Yes.
My lord, respond number 4 and 5. I am Sujan Sagar. I am the executive officer, Diga Comfortable. I am not on the denial. Then kindly come to page 3.
Just a minute. Page 3
Page 3.
of the affidavit in opposition.
My lord.
Yes.
Last paragraph. I state that thereafter, during the divisional settlement operation, the state plot was subdivided into 3 plots, being RS plot number 1800 original, measuring about 2.13 acre, RS plot number Batada 1800 by 2160, measuring about 0.20 acre, and RS plot number 1800 by 2208 Bata, measuring about 0.11 acre. As the original PS plot number 1800 was acquired in its entirety, the question of acquisition of the said Bata plot did not arise. My lord, dear my lord, my lord, sorry, my lord, the PS3 second paragraph. I state that original PS plot number 1800 in Mouja, Hadal Gobra, jail number 86, measuring 2.44 acres, was acquired in its entirety by the government of the development of Diga in LA case number 5556. First time we came to learn the LA, the entire plot was, my lord, acquired. First time we came to learn. Thereafter,
Just a minute, sir. Just a minute. Yes.
my lord. My lord, thereafter they stated.
So
that-
according to them, the land acquisition took place on 14th
55.
October 1955.
55.
Your deed is subsequent to that.
Subsequently. Then these are no value. Gone. Thereafter kindly come to my lord, page 3 last portion. Question of acquisition of the state Bata plot did not arise. However, for some unknown reason and due to inadvertent, the two Bata plots were wrongly recorded in favor of previous landowner Anjali Khan. I state that Diga Sunkarpur Development Authority filed objection to such wrong recording and the block land reform officer Ramnagar 1 after hearing the same passed an order dated September 6, 1994 for recording the said two plot in favor of DSGA. Accordingly, the same was duly recorded. I state that Diga Development Scheme had prepared a layout.
So record of right has been corrected.
Correct.
The corrected record of rights has been annexed.
My lord.
And letter B.
My lord. One by one, my lord. Kindly come to page. My lord. Page 6. Page 6 of the affidavit in opposition. Page 6.
No, wait. Proshashok 1800 and 18210. Sabek Dak, so 1979, 1978. Your land is also in on 1979 and 1978?
Yes, ma'am. First, my lord, kindly come to page 6 of the affidavit in opposition.
Give me a second, sir. 186 is a part of 1800, 2208. When it has been recorded? September 1994.
My lord.
Yes.
My lord, kindly come to page 6 of the affidavit in opposition. Mouja Kadla Gobra.
Page 6.
Page 6.
Page 6 is the.
My lord, the plot number. Various plot number.
Page 6 of what, sir?
The affidavit in opposition.
Of the requiring body?
My yes, ma'am. Diga Development Authority.
That is, the deponent is known to me, something like that.
No, and it's, matlab, then matlab 8A. 8A.
Oh. 8A. Internal page 6.
8A.
Huh.
8A. Mouja Kadla Gobra in the middle portion.
Yes, I got it.
My lord, tag number 1800. Got it, my lord? This portion, my lord. 1800.
Huh.
My lord. Then kindly come to, my lord.
This is the type copy of the notification.
No, yes, notification. Then kindly come to page 9. Certified copy of the order passed in the objection case. Kindly note down that number 470.
Which portion?
Page 9.
Huh.
At the top, certified copy of the order passed in the objection number 470 under section 51 capital A 1 of WBLR Act 1955 86. The order passed on 15th May 1995. Got it on the left hand side. Order dated 15th May 1995.
15 May.
This portion. 15th May 1995.
15 May is something. This is an important document relating to the land near NM Market. No, this is an endorsement.
11/8/1994, issue notice under section 51, read with section 51, capital A of WBLR Act. There are the decision, grounds for decision and order. On behalf of the objector, Mr. Monigopal Chondo appear and file Hajira. None represented the OP or appear even after repeated call. Heard the representative of the objector and examine some document like the notification of the development and planning department, government of West Bengal, published in the Calcutta Gazette on December 11, 1972. D form part submitted by one Mrs. Anjuli Khan and other, and memo bearing such and such number. The objector's case in brief is that the case plot being number 1800 by 21660 and 1800 by 2208 of Mouja Khadal Gobra, subsequently renumbered in the present settlement 1979 and 78 respectively, were made but during the RA, but before that they were with the original plot number 1800, having its total area of 2.44 acre of the said Mouja. The said land, that is plot number 1800 by 242.
No, there is a measurement, not bata. 1800 measuring about such and such acre.
Was acquired by the government for the purpose of development of Bida in LA case number 16 of 1950-56 under notification number such and such from the erstwhile recorded claim on payment of compensation as due. But before the state department could take effective step for incorporation of the land in the RO1 in its favor, the aforesaid plot number such and such was made 3 bata, and the one with area of 2.13 acre was allocated the original number, that is 1800, and the two being the instant case plot for reasons unknown were recorded in favor of late Amorendra Lal Khan, husband of the present OP. The department could recorded only the original plot, but the case plot left unrecorded in its favor and were wrongly recorded in favor of said Khan. The documents since produced during the hearing conclusively prove the above observation. The above is indirectly confirmed by the fact that in the B form submitted by the Mrs. Anjuli Khan and others on 24/12/85, there is no mention of case plot that they have been retained by them. Then objection decided expertise allowed in favor of the objector.
Just a minute, sir. The said land in plot number Ato was acquired by the government for the purpose of development of that case number Ato. That is plot number 1800, from which 2 bata plots have come. Very good. Thereafter, what happened? Under notification, just a minute. From the erstwhile recorded tenant on payment of the compensation. This much I have understood. But before this said department could take effective steps for incorporation of the land in the ROR in its favor, the aforesaid plot number was made 3 batas, and the one which area 2 point was allowed with the original number 1800, and the other is other instant, and other 2 being instant case plots. That is 1800 bata such and such, 1800 2160 and 18. Very good. For unknown in favor of the department could record only the original plot, but the case plot left unrecorded in its favor and were wrongly recorded by the said Khan. The documents is produced during the hearing conclusively prove the assertion. The above is indirectly confirmed by the fact no, if 1800, the entire plot has been acquired and in the event the said original plot has been subdivided into 3 pata plots, it must be in Khotiar number 1.
Yes, my lord. It must be Khotiar number 1.
Then what is your objection? That I cannot. But what is the objection of Noni Gopal Chando or something like that? I cannot understand.
That's right. I purchased the land from
Mr. Chatterjee, please listen. So,
after completion of my
sir, please answer to my question, not to him. So far as the plot number 1800 is concerned, that is the mother plot.
mother plot.
It has been subdivided into 3 pata plots,
Pata.
rather 1 mother plot and 2 pata plots, 3 plots. So it must have been recorded in the Khotiar number 1.
My
For some reason or other, it has not been recorded. It has been recorded in some other person's name, who is according to you is your vendor.
I purchased the land from Kanailal Kaur.
No, what I am on, what is the finding, penultimate finding, that I cannot understand.
This proceeding,
Hmm?
proceeding penultimate finding order in Bengali. সুতরাং আদেশ হইল যে সংশ্লিষ্ট মৌজার 1800/2160 দাগে 205 এবং 1800/2208 দাগে 1150 নম্বর অধিগ্রহণ কে 95-96 মূলে বাদী 253 নম্বর খতিয়ানে রেকর্ডভুক্ত হইবে এবং 39/4 খতিয়ানে ভূমাত্মক রেকর্ডটি বাতিল হইবে। This is the ultimate penultimate paragraph. Noni Gopal Chando appointed for the administrator Diga Development Scheme. Noni Gopal Chando on behalf of Diga Development Scheme. And opposite party number 2, Bonjuli.
Who is the body here?
Malad kindly have a look into 3 Noni Gopal Chandra.
অধিগ্রহণ কেস মূলে বাদীর 2 নম্বর ও 3 নম্বর খতিয়ানে রেকর্ডভুক্ত হইবে এবং very good. Then what happened?
Then what happened? Then my lord kindly come to their page 10. মানে মৌজার নাম থানা দিঘা শ্রীমতী অঞ্জলি খান নোটিশ শ্রী অঞ্জলি খান 19/8/1994 ধার্য হইয়াছে। এত দ্বারা আপনাকে অবগত করানো যাইতেছে উক্ত তারিখে 12 ঘটিকার সময় উপস্থিত থাকিবেন রেভিনিউ অফিসার নোটিশ। And thereafter page 11 objection number 470, that is 470 without any my lord date, that is 417 GR number 75 name and প্রশাসক দিঘা উন্নয়ন প্রকল্প দিঘা মেদিনীপুর 1 নম্বর অঞ্জলি খান 2 নম্বর বিএলআর দাগ নম্বর 1800/2160 1800/2208 হাল দাগ নম্বর 1979-1978 মহাশয় উপরিক্ত বার্তা দুটি দাগে মূল দাগ সিএস নাম্বার 1800 এলএ কেস নাম্বার 16 of 1955-56 সালে পশ্চিমবঙ্গ সরকার দীঘা উন্নয়নের জন্য অধিগ্রহণ করিয়াছিলেন, যার নোটিফিকেশন নম্বর 225 এলএ ডেটেড 14/3/56 উক্ত মূল দাগে মোট জমির পরিমাণ 2.44 একর, কিন্তু 1962 সালের সেটেলমেন্টে 1800 ডাকটি বাটা হইয়া সার্চ অ্যান্ড সার্চ এরিয়া যথাক্রমে এত ডেসিমেল শ্রীমতী অঞ্জলি খান এবং শ্রী অমরেন্দ্রলালের খানের নামে রেকর্ড হইয়াছে। মূল দাগ 1800 এরিয়া 2.13 ডেভেলপমেন্ট বোর্ডের নামে রেকর্ড হইয়াছে। বর্তমানে উক্ত জমি দীঘা উন্নয়ন প্রকল্প PS কেস নাম্বার 179 হইয়াছেন। বর্তমানে তদিকের সময় মূল দাগ 1800 প্রশাসক দীঘা উন্নয়ন প্রকল্পের নামে রেকর্ড হইয়াছে, কিন্তু বাটা দুটো দাগ প্রশাসকের নামে রেকর্ড হয় নাই। উক্ত বাটা দাগগুলি যাতে প্রশাসকের নামে রেকর্ড হয় তার সুব্যবস্থা করিয়া
Naturally, if the original plot has been acquired, then the Bata plots ought to have been recorded in the name of the.
Then kindly come to page 12.
So page 11 is the objection of the authority, development authority.
Then my lord kindly come to page 12. But here I may be wrong. No date is mentioned.
Be that as it may, what happened thereafter?
Thereafter, page 12, the executive officer Diga Pankapur Development Authority information regarding acquisition of cadastral survey plot number 1800 in Mouja Khadal Gobra, such and such, and they stated that criminal settlement.
Since the full area of such and such was acquired by the government in LKS now, therefore non-acquisition of Bata plot number does not arise at all the relevant records. So what is your submission?
Yes, madam. This is the submission on behalf of the Diga Development Authority. Then kindly come to
So
my
far
reply.
I have understood from your submission and from the documents
This is
that
only I am reading, my lord.
I understand.
By date.
So,
But that case.
so it is the case of the requiring body. The mother plot is 1800, from which two separate batas have been created. In LA case number such and such 16 of 1955-56, entire plot number 1800 has been acquired. So therefore, the recording, subsequent recording in respect of the Bata plot number 1800/2160 and 1800/2208 are wrong. So it should be recorded in the name of the recording body, because the entire plot has been acquired. I believe it is the case of the respondent. And your purchase property is in the Bata plot.
Fine. Then kindly come to my reply.
Very good. Reply to
choice survey order আছে orderটা কত
respondent order. 4 and 5.
My lord, my evidently reply, page 2.
Just a minute. 2nd December.
My lord. No, my lord. 30th July 2018.
Oh, it is the land acquisition collector. Affidavit in opposition to follow. Reply.
30th July 2018.
July 2018. Give me a second. Yes. Yes, sir.
My lord, kindly come to page 2, paragraph 4.
Page 2.
Paragraph 4. Paragraph 4, मतलब Roman 2, मतलब subparagraph Roman 2, page 3, my lord. The said plot originally belongs to one Anjali Khan, being the owner since deceased, and she moved a repeat application before the Honorable High Court at Calcutta, being WP number 2511W of 2004, against the irregular and illegal activities of the respondent authority for taking stake for construction without paying compensation to the petitioner. And on 14th June 2004, his lordship, the Honorable Justice Baring Ho, as his lordship then was pleased to dismiss the said application with the observation that as the land stood recorded in the name of the petitioner in the record of right, which itself suggests that the land was not acquired, so the question of payment of any compensation does not arise. Kindly come to that order first. Page 9.
Just a minute.
Under page 9, my lord. Got it, my lord?
Got it.
My lord, that time, my lord, the cost title we have to write the, kindly have a look into the last cost title of page 9, acquisition of land measuring an area of about 222 acres of CS plot for the Diga development project in village Postim Gadarpur, Khadalgobra, Bangi, Bharampur, Bill, Amaria, such and such for the public purpose. Hereafter, page 8, very important. Irregular interference of the respondent number 7. Who is respondent number 7, my lord? The Bulgaria Central Cooperative Bank. Respondent number 7, page 11. My lord, kindly come to by taking step.
Mr. Chatterjee,
Again,
come to the point.
yes, my lord.
Whether while disposing the writ petition, the learned single bench at all observe that the LA proceeding
Yes,
has
my lord. That's
been set aside.
But yes, my lord, lordship, kindly.
The subject matter is whether the writ petitioner is entitled to compensation or not.
My lordship,
The court found that the recording is still in the name of the writ petitioner. Therefore, the compensation does not arise.
kindly have a look at page 12.
Sir, I am on that.
Lordship, kindly for 1 second, my lord. It is claimed that in 1955, a section 6G declaration was issued in respect of land being the subject matter of the writ petition. It is shown in certain annexure to this writ petition. Even on 5th January 1984, the land stood recorded in the name of the petitioner in the record of right. That itself suggests that the land was not acquired. Land was not acquired. That itself suggests
It is a consequential finding.
no, my lord.
It is a it is not the judgment of the writ. It is not the judgment of the writ.
Hereafter, petitioner is seeking compensation when the lands are not been acquired. The question of payment of any compensation does not arise.
Very good.
My lord, the order of the writ petition.
I understand your submission. That by
carries-
virtue of this, by virtue of this order, you want to avoid the land acquisition proceeding.
No, my lord.
That cannot be done.
No, hereafter, this is the additional point. Hereafter, kindly come to page 40.
Huh.
Page 40. My lord, that is page 40. I have taken it, page 4 of Roman 3, Riga Development Authority.
Page 14,
Page 4, Roman 3.
internal page.
Page 4 of Roman 3. The Riga Development Authority recorded their
Just a
name.
minute, just a minute, just a minute.
Page 14, my lord, or page 4? Page 4, my lord.
You are referring which page?
मतलब first page 4, Roman 3, my statement. Bigger Development Authority.
No, you referred page 12. Thereafter?
Page 40.
14. Yes.
The minor, that is, on the proceeding in the matter of Timothy Anjali Khan versus Administrator Bigger Development Authority. The case is taken up today in the year 2008, 10th January 2008. The case is taken up today for hearing and disposal. Learned advocate A.K. Jana appeared on behalf of the appellant and filed Hajira, but the respondent is absent through notice duly served. Hard, the party at length examined meticulously the memo of appeal, the LCR being case number 417 under section 51A1 of WBLR Act on Moja Khadalgobra Jail 86, information of LA Collector Purbo Mednipur by the memo number such and such dated 2nd January 2008. The copy of the judgment is WP number 2511 of 2004. The order dated 24 June 1996 passed by Honorable Justice N.K. Mitra in CO number such and such and other ancillary paper produced by the appellant side at the time of hearing on several dates. My lord, kindly match the evidence of opposition that number 470. Kindly match the number, page 9, evidence of opposition, case number 470, and here also 470.
Just a minute, sir.
Acquisition possible.
Just a minute, sir.
The fact,
Mr. Chatterjee, wait for a second.
my lord.
Wait for a second, sir. Yes, matching. Which matching is required?
My lord, first matching with case number 470, page 14. My lord,
Page 14 of?
page 14 of my lord, every reply. The case number, my lord, mentioned by the my lord, appellate court, appellate authority under section 51A of WBLR Act. Case number 470. What is my lord? 1, 2, 3, 4, 5, 6, 7 lines from the top. 470. LPR being case number 470 under section 51A1 of WBLR Act of Mauja Khadal Gobra, jail number 83. What is my lord? And then opposition page 9 at the top 470 page line legal development authority.
Opposition?
In the opposition, they are opposition. Page 9.
Give me. Just
I may be wrong. I may be my lord misguided the court. So my lord, that nothing is required.
which one?
Page 9 of the evidence in opposition. At the top. At the top 470. Objection case number 470 under section 51A of WBLR Act of Mauja Khadal Gobra, jail number 86. At the top. And then page 14.
Page 14 of the
Page 14 of the
reply. So, what do you want to say?
But that case record produced before the 470 objection case number relied by my learned senior friend. That case was considered, LPR was called for by the appellate authority on 10 January 2008. Page 14.
But this finding is in your favor. So far as page number 17,
in my favor.
page number 17, last but 1, 2, 3, 4, 5, 4 paragraph.
4 paragraph and page 18 set aside. Which case set aside? For 17 case set aside. And for that reason, thereafter no appeal. So this is not writ petition. This is binding upon all. It is not a mere order of a writ petition. Thereafter, page 19. Another important.
Just a minute, sir. 14, 17, 18.
And here also, my learned junior, my lord, mentioned page. And part of load also mentioned, my lord, in the middle portion, page 70. My lord, kindly come to page 70 in the middle portion. My lord, this is most vital issue as to whether the land has since been acquired or not. In the disposal of objection case number 417 under section 51A, subsection 1 of WBLR Act of Mauja Khadal Gobra was held that the good land has been acquired.
I got your point. So by this order, the acquisition has been set aside.
Set aside. And thereafter recorded one by one. Then kindly come to page 19. Page 19. 15 Hotel Private Limited filed way before the West Bengal Land Reform Tenancy Tribunal for record his name in the LR record of right on 20th July 2010. Today 24.
Mr. Chatterjee, I got your point. Just tell me, please reply to my.
Oh my Lord.
Mr. Chatterjee, reply to my question. Whether the finding of the authority, appellate authority. Listen to my question, sir. It is only 12:30. I remain in court at least 6:30, 7:30, 8 p.m. Listen to my question first. Whether the order of the appellate authority as on 10/1/2000 2000 or 2008, something like that.
2008.
2008, whereby it has been held that the such and such plot were not acquired in the case proceeding has been set aside by any higher authority.
No, not only that, my lord.
So practically,
Landlord-
I believe it would be your submission that by virtue of this order, by virtue of this appellate authority's order, the LA proceeding, if there be any, as on this day, stood set aside.
And not only that.
So therefore, they have got no. Therefore, the record of right, as on today, is perfectly justified, and therefore the development authority has got no right at interest over the property, and accordingly they have no right to disturb your position. I believe this is your case.
My lord. So one thing, my lord, additionally, my lord, one point may raise that BLRO wrongly recorded, not may. They already, my lord, pointed out that BLRO wrongly recorded in my name. In the LR record.
No, your reply is that the LA proceeding was set aside by the appellate authority.
Not only that, LRTT, Honorable LRTT passed an order.
Passed an order for consideration.
Not so, my lord, not the my lord, candestial manner. I recorded the name. In a nowadays,
Very good. So far as 12 o'clock matter is ready. I'll keep it tomorrow at 10:30. As item number 1.
Tomorrow at 2 p.m. my lord.
2 p.m. not possible.
Tomorrow,
2 p.m. তো আমার সঙ্গে জাস্টিস সরকারের একটা
may I make a submission?
কালকে ফ্রাইডে না? Why not 10:30 sir tomorrow?
You respect that one matter, my lord, already.
Tomorrow I will be also.
12 o'clock?
Tomorrow I will be in some difficulty. Tomorrow is a Friday, lordship knows all the broken benches and contempts are taken. All the
Sorry?
broken benches or contempts are taken up on Fridays tomorrow. I'll be in some.
No, I'm to conclude this.
I have to reply to your lordship's query, my lord.
Definitely. I have fixed matter at 12 o'clock, no?
That's right. My lord, can I come back today and make the reply if your lordship allows me?
2 p.m. I have some original side matter.
But I'll try to reply today because whatever documents I have in on record.
Very good, very good. Matter is very simple, I believe. Not very much.
Kindly allows me to make submission.
Yeah.
You make your submission. I will not grant adjournment. Then wait. I am ceasing over the matter. Wait.
Well, if your lordship allows me 20 minutes time now, right now,
No, I have a fixed 12
at
o'clock
12:30,
matter.
that gentleman.
It's already 12:30.
But I can wait after he finishes. I can start.
You come back at 3 p.m. then. 3 p.m. sir, Mr. Chatterjee, today. 3 p.m.
Valid advocate for the petitioner, senior advocate, and senior advocate of the valid advocate.
Sir, don't seek an accommodation. Who is for the petitioner? 12 o'clock matter.
I'm for the petitioner.
Why is your senior?
My senior is just my humble submission, let it be fixed at main faculty tomorrow, my humble submission, let it be fixed at 10:30 without assigning any time. It is number 1.
Where is your senior? No, if the matter is adjourned till tomorrow, then I can continue with this matter. Where is your senior?
Let it be fixed on tomorrow. Without
I'll continue with this. I'll continue with this.
let it be fixed on number 1.
Hey, এক second আসুন তো। May I fix it on tomorrow at 10:30?
10:30.
এটা item number?
Item number 1.
এটা লিখে রাখো তো। Give me 5 minutes, I will come by 5 minutes and I'll get
Valid.
Continuing in the this matter of challenge
No, only 12:35 minutes, sorry.
My lord, with item number 6, my lord.
I cannot say, I cannot give you any assurance, sir.
My lord, item number 6, my lord. My
Mr.
lord,
Chatterjee, have you concluded your submission?
Only, my lord, only one thing, my lord.
my lord, before Mr. Chatterjee begins, my lord,
Sorry, we cannot.
my lord, item number 6, my lord.
Sorry.
My lord, now, after the order of the appellate court, no challenge before any other court.
That you have
Therefore,
submitted.
they stop. To, my lord, take this point, already they stopped in the year 2010, order passed in the year 2008.
So appellate authority's order has become final.
Fine.
So according to
binding
you,
on
land
all parties.
acquisition has been set aside.
Right.
So there cannot be any doubt with regard to the there cannot be any doubt to the title of your vendor. So according to you, your title is perfect, which should not be interfered. I believe this is your
Yes, my lord.
submission.
Yes, my lord.
Very-
And all are unimpeachable sterling documents.
Very good.
Because.
Yes, sir.
Now, my lord, as I, my lord, had submitted earlier, I appear for the requiring body. Now, my lord, state will obviously make its
Requiring-
submissions, but my lord, kindly
Requiring body is
the Diga
respondent of-
Shankarpur, respondent number 4 and 5, Diga Shankarpur Development Authority.
respondent number 4 and 5.
Lordship.
4 and 5. Mr. NCPN,
Lordship.
right?
Lordship,
Am I right?
I'm deeply obliged.
Very good. Make your submissions.
Now, my lord, I will be making my submission from the point of view of the requiring authority.
Of course.
Now, my lord, kindly takes the writ petition once. I'll be very as short as possible.
Very good.
Kindly takes the writ petition once. Now, my lord, immediately, my lord, initially kindly turns to the prayer portion at page 11. My lord, this was the prayer with which, my lord, the learned friends come up before your lordship. Page 11.
Yes.
Well, mainly two prayers. Kindly sees prayer A,
Hmm.
reading the nature of mandamus, commanding the respondent authority, especially the respondent number 5, that is the executive officer,
Yes, sir.
to take immediate steps to stop illegal digging of the land belonging to the petitioner. That is the first prayer. And prayer B is, my lord, to mandamus to the respondent authorities to restore the land belonging to the original shape. So that to stop digging, and if the digging has been made, to restore it to the original position. My lord, these are the prayers in the writ petition. My lord, kindly mark, subject to correction by your lordship, no prayer, which, my lord, in my actual submission, I will be elucidating that he cannot make. No prayer for, my lord, what has been submitted before your lordship right now, that land has been, that acquisition has been set aside, and land should be, I should get back the land. No prayer. Prayer is only, I have made 144, illegal digging, stop that. Stop encroachment by the respondent authorities. That is the prayer in the writ petition. My lord, in my actual submission, number 1, he cannot proceed beyond the prayers made in the 4 corners of the writ petition. Number 1. Now, number 2, my lord, kindly takes it on merits. My lord, kindly turns to page 15, I believe, of the writ petition, which is the, my lord, Bikroy Kovala, the sale deed. But I shall not place it in details, but only the point I need, my lord, I'm attempting to make is that page 15, lordship will find the Creta is Siskin Hotels at page 16.
There is the writ petition.
That is a writ petitioner. And Bikreta is Sri Kanailal Dhar at page 16. Now, my lord, subject to correction again by your lordship, lordship will find, my lord, I have not found the antecedents from where Kanailal Dhar gets it from Srimati Anjali Nag. So, my lord, the second point is I am challenging the locus of the petitioner. Kanailal Dhar, how he gets it from Anjali Nag, because his lordship will find in all the documents Anjali Nag. How Kanailal Dhar gets his title from Anjali Nag. At least from subject to correction, at least from this sale deed, it is not evident. It is a 3-page sale deed. Now, my lord, lordship will now take my affidavit in opposition. My lord, affidavit in opposition by Sri Sujan Dotto, the then executive officer. Lordship has got it?
Yes, it is
I'm
with
deeply
me.
obliged. Well, kindly straight away turns to the Gazette at page 8.
Page 8.
Lordship, the Gazette, extraordinary Gazette.
Hmm.
Now, my lord, kindly see the right hand column. After the numbers, kindly see Mouza Khadal Gobra, jurisdiction list number 86. Lordship has got it. At the right hand column, my lord, at the top some numbers are there. Then just below that Mouza Khadal Gobra, jurisdiction list number 86.
Yes.
I'm deeply obliged.
1800 is also there.
1800 is there. Now, my lord, kindly comes down to the last paragraph, starts with the highlight Midnapur.
Yes.
Now, my lord, may I just place this? 14th October 1955, whereas the governor is satisfied that the land is needed for a public purpose, not being a purpose of the union, namely for the Digashankarpur project in the village of Paschim Gadadarpur, serial number 88. So, my lord, this is the declaration under section 6 of the Land Acquisition Act 1894, wherein, my lord, plot 1800 is acquired in its entirety.
Sorry?
The plot 1800 is acquired in its entirety. Now, my lord, kindly the remaining pages are, my lord, the typed copies. My lord, kindly turns to page 9 of that affidavit. Now, my learned friend has placed it. May I just place some parts of this?
Yes.
Page 9 of the affidavit.
Hmm.
Now, my lord, I state in the affidavit that, my lord, the plot after acquisition was, my lord, wrongly recorded in the name of Anjali Khan. Now, my lord, before your lordship takes page 8, kindly turns to page 11. This was the objection raised by the authority before the land reforms officer. Page 11 is the objection.
Your objection.
My objection. On the basis of which page 9 comes in.
Yes.
Page 11 is my objection. Kindly see column 1.
Proshashok Diga
Unnayan Prakal.
Your client.
And kindly see column 5 now. Matters objected to. Well, I'll not trouble your lordship with everything. This is, my lord, 8th line from the, my lord, that column. It starts with road se naam record hoyi ache. If your lordship gets that. 8th line starts with road se naam record hoyi ache.
1, 2, 3, 4, 5, 6, 7, 8. Roads এর নাম শ্রী অমরেন্দ্র লাল খানের নামে রেকর্ড হয়েছে।
No, I'm not on that. Lordship has found that line roads এর নামে রেকর্ড হয়ে আছে।
ডেভেলপমেন্ট রোডস এর নামে রেকর্ড হয়েছে।
দেন বর্তমানে উক্ত জমি দীঘা উন্নয়ন প্রকল্প টিএস কেস নাম্বার সাজান সাজের মূলে দখলিদার হইয়াছেন। বর্তমানে তাহাদিগর আমার মূল দাগ নম্বর 1800 প্রশাসক দীঘা উন্নয়ন প্রকল্প গ্রামে রেকর্ড হয়ে গেছে, কিন্তু বাটা প্লট দাগগুলি দ্যাট ইজ 1800 and 2160 and 1800 2208 প্রশাসকের নামে রেকর্ড হয় নাই। উক্ত বাটা দাগগুলি যাহাতে প্রশাসক দীঘা উন্নয়ন প্রকল্পের নামে রেকর্ড হয় তাহার সুব্যবস্থা করিয়া বাধিত করিবে। So this was the objection by my client. Now, my lord, kindly turns to page 9 of the opposition.
Yes.
Now, page 9, lordship will top will find present on behalf of the objector. My lord, lordship will get fallen from your lordship. Who is Noni Gopal? Noni Gopal Jana Chondo appeared on behalf of the Diga development scheme. The objector. Now, my lord, kindly sees the order. The second paragraph, the objector's case in brief is that the entire plot, the case plot that is 18002160 and 18002208 of Mouda such and such, subsequently renumbered in the present settlement as 1979 and 78 respectively, and made Bata during the arrest, but before that they were with the original plot number 1800 having total area of 2.44 acres of the above Mousa. That's the, I'm just, why I'm placing this, it will be required later on.
Please.
I'm not deeply. The purpose of the acquired by the government for the purpose of development of Diga in LA case number such and such, under notification of such and such from the recorded tenant on payment of compensation as due. Will kindly mark this once on payment of compensation as due. So the payment of compensation is admitted. Then, but before the said department could take effective steps for incorporation of the land in the ROR in its favor, the aforesaid plot number 1800 2.5 was made into 3 batas, and the one with the area of 2.13 acre was allotted to the original number 1, that is 1800, and the 2 being the instant case plots were reasons unknown, and later were recorded in favor of late Amarendra Lal Khan, husband of the present OP, who is the OP Anjali Khan. The department could wrongly record, department could record only the original plot, but the case plots left unrecorded in his favor and were wrongly recorded in favor of the said Khan. The documents since produced during the hearing conclusively prove the above stated considerations. The above is indirectly confirmed by the fact that in the B form submitted by Mrs. Anjali Khan and others on 24/12/85, there is no mention of case plots they have been retained by them. Hence, the objection decided expert in the of them. Kindly marks it. Well, in the return, they have not claimed this. Well, then in the Bengali, subsequently it has been recorded in the favor of Diga Development Authority. Now, my lord, kindly marks the date of this order. At the bottom, 6 September 1994. Well, this is very important. This order, re-recording it in the favor of the authority, 6th of September 1994. My lord, kindly marks this. Now, my lord, kindly.
Just a minute, sir.
I'm sorry.
Yes, sir.
Now, my lord, kindly now turns to page 12 of the opposition. My lord, we had in 2011, my lord, this is pursuant to the order passed by the DLLRO, which my learned friend has placed in the affidavit in reply. This is dated 2011. My lord, we write to the LA collector, Purva Medinipur. Kindly seize the letter at page 12. But I am on paragraph 2.
For recording your name.
No. But we say the Diga development scheme is recorded in LR department and its possession till now. The aforesaid area 1800 was 2 point, but during this is the Bata. Since the full area was acquired by the government and therefore non-occasional Bata plans does not arise, all the relevant records are annexed herewith. The relevant records are of 1996. The recording of my name of the Diga Development Authority.
So 94.
96.
6/9/94 the order was passed.
Yes.
And you approached the LA collector on 2011?
No, I approached the LA collector for clarifying it because the LA collector informed us what is the present position. That I have stated in my affidavit. Now, kindly take the averment in the affidavit. I tell your lordship. Kindly takes page 4. Kindly takes page 4 of the affidavit. Kindly takes the last paragraph. Sorry. That a notice was served upon the DSDA by the Block Land and Arrangements Officer in Meets case number 18 of 2011. Accordingly, DSDA submitted the facts pertaining to the land in question on October 13, 2011. That is the annexure, my lord, at page 12. So, my lord, as of now, from the documents, my lord, I have placed before your lordship, land in the name of DSDA stood recorded on 6 September 1994.
I can't follow.
As of, my lord, till the affidavit in opposition, on 6 September 1994, the records were re-recorded in the name of Diga Development Authority by the order of the competent officer.
But your annexure, your submission does not match with annexure C.
No. Well, page 9 is the recording at annexure B. Recording in my favor. That is in 1994.
After considering your objection.
Yes. Now, since the, my lord, the, since the BLLRO, in a Meets case of 2011, served notice upon us, asking, my lord, requiring what is the present position, annexure C is clarifying the present position. We say all the relevant records in this regard are enclosed herewith for your perusal, enclosing therewith page 9 also of 1994 order. This is just a reiteration of the position as it was.
Very good.
Lordship. Now, my lord, kindly now, the one of the where the case rises, kindly now take their affidavit in reply, which my learned place friend is detailed where that order is also enclosed. This is by Hemant Kumar Mishra.
Yes.
Now, kindly takes page 3. My learned friend has placed this, my just placing it. Page 3, column Roman 2. That the said plots originally belongs to one. I'm sorry.
Page 3.
Page 3, Roman 2.
Yes.
That the said plot originally belongs to an Anjali Khan being the owner since this is, and she moved a writ application such and such against the irregular and illegal activities of responsibilities for taking steps for construction without paying compensation. And on 14 June 2004, my lord, this honorable court passed an order. Now, my lord, kindly turns to that order at page 12. My lord, in my respectful submission, my lord, this is why, my lord, I'm taken trouble of your lordship to my lord, indicate the date of the, my lord, recording of 6th of September 1994. Now, my lord, kindly takes page 12. It is claimed that in 1955, a section 6 declaration was issued in respect of lands belonging to the subject matter of the writ petition. It is shown in certain annexures to this writ petition. Now, kindly marks it that even on 5th January 1984, the land stood recorded in the name of the petitioner in the record of rights. So, the honorable court on that, my lord, in this order, proceeded on the basis that in 1984, the original record stood recorded in the name of the petitioner. Whereas in
1994 document was not placed.
Not considered. Well, I am deeply obliged. Not considered.
The 94 document has not been placed before the his lordship as it was.
In my lord, when his lordship passed the order in 2004. So, my lord, the honorable court proceeded on the basis of a recording of 1984 when 1990. I'm sorry, no, my lord, yes, 84 when 1994 was already recorrected. So it was not placed. It was not in knowledge of the honorable court. And since that was not placed, his honorable lordship had held, my lord, that it appears that the lands have not been acquired when it has been acquired in 1955 by the state. I shall take your lordship to the state's affidavit also of the document. The lordship is in. Now, my lord, kindly takes the main order of the DLLRO, which my lord has at page 14.
Yes.
Now, my lord, before I place this, my lord, my respectful submission is that one difference, my lord, in my respectful submission, by this order, the recording of the Diga Shankarpur development's name in 6th September 1994 has been cancelled. Not the acquisition. The DLLRO cannot cancel the acquisition. He has cancelled the recording. The acquisition remains. And if the acquisition, I should place it, if the acquisition has been made and possession handed over, well, this cannot be challenged. Now, kindly see why I make this submission. Kindly see this second paragraph, last paragraph of page 14. The fact of the case is brief is that the name of the Diga Development Authority has been recorded in the case being 417, which is page 9. And 51A of the against plot number 18002160 and 1800 Bata 2208 for an area of 20 decimals, 11 decimals respectively of Mauza such and such, which was recorded earlier in favor of Anjali Khan. So that is the present position. Now, my lord, kindly turns to page 15. Now, kindly sees the second last paragraph, penultimate paragraph. On perusal of the LCR, being objection case number.
The order has been passed by the SDLRO.
No.
Who is the appellate authority?
Appellate authority.
Officer specially empowered under subsection 3 of section 54 of the Who is that authority? You don't know. Have idea?
Well, like now DLRO. But
Now
DLRO.
Now DLRO at that point of time possibly is DLRO.
But now DLRO.
Anyway.
Now, kindly see page 15. The second last paragraph.
Yes.
On perusal of the LCR being objection case number 417 under section 51A1 in question has been acquired in the LA case number such and such, and the suit land has not been retained by the owner in his B form. So, my lord, admittedly not retained, acquired, not retained till now. Now, my lord, kindly takes the next page, page 16. Why, my lord, the authority proceeded on this basis is clear from here. Kindly take page 16. Issue number 1. My lord, kindly skips a few lines. It starts with, in this instant case, the appellant has moved before the Honorable High Court. In the middle. Lordship has got it? I am deeply. In this instant case, the appellant has moved the Honorable High Court through such and such of 93 being agreed with the order passed by the Learned Revenue Officer in objection case of 417. In order dated 24/6/96, the Honorable Justice N.K. Mitro has directed to prefer appeal. Hence, this appeal is preferred. So, this appeal was preferred by my learned friends against the order by Justice N.K. Mitro in another writ petition. By Justice N.K. Mitro in another writ petition, whereby, my lord, his lordship, as his lordship then was pleased to dismiss the writ petition, holding that since since it has already been recorded in favor of Diga Shankar authority, go and file an appeal before the appellate authority. So that was the genus from.
Case the appellant was to move the Honorable High Court in.
Yes, kindly see.
This is few.
Yes.
Being agree with the order passed with the appellant, objection after. Honorable NVSD NK directed the.
Well, that order was by Justice Barin Ghosh. This is by Justice NK Mitro. Has directed to prefer appeal, hence this appeal. Now, my lord, kindly takes page 17.
Appeal against the order dated 9/6/1904?
Yes, absolutely. Now, my lord, kindly takes the page 17. Next page. This is most vital issue as to whether the land has since been acquired or not in the disposal of the objection under 417 of the such and such. It was held that the suit land has been acquired in LA case numbers, but it is evident. My lord, kindly mark this word.
So, which portion you are reading?
From the top. Right from the top, my lord. Issue number 2, this is most vital.
Yes, sir.
Issue as to whether the land has since been acquired or not in the disposal of objection, case number 417 of WBLR Act of Moza Khadal Gobra. It was held that the suit land has been acquired in GLA case number 15 of 1955-56. But it is evident from the judgment in WP number 2511 of 2000. Kindly marks it. This is the order, my lord, judgment of Justice Barin Ghosh as his lordship then was, when, my lord, 1996 recording was not placed. It is evident from the judgment of WB number such and such of 2000 that the land in question was not acquired. Not
so
only
why
that,
you are not challenging any, preparing any appeal against this finding?
So that possibly has not been done. I have to take instruction on that. But the authority proceeded admittedly on the basis of, my lord, that judgment of 2004, wherein, my lord, the lordship, my lordship had relied on the 1984 recording without considering, because it was not placed before his lordship, the 1996 and 1994 recording in favor of Diga Shankar. That is the genus of this entire order. And he cannot, my lord, lordship will kindly go on, kindly see, he has not, my lord, that was possibly, my lord, a mistake on our part to submit before your lordship that the land acquisition has been cancelled. It cannot be. The recording was cancelled. There's no, my lord, lordship knows the difference. Now, my lord, kindly sees what he holds now. Now, lord, kindly comes right at the bottom. Considering the circumstance.
I believe I have understood your submission.
Lordship.
That whatever order which has been annexed with the affidavit in reply.
Lordship.
If you are wrong, please correct.
No, not correct.
Feel free.
Lordship.
Otherwise, it would go against your client.
Lordship.
Your first fold of submission that in the writ petition there is no prayer for cancellation of the land acquisition proceeding.
Neither for compensation.
Nor for compensation.
Lordship.
Your second fold of submission is that even then, even if the appellate authority passed an order for correction of the record of right, the said authority has got no power to cancel the land acquisition proceeding.
And he has not done so also.
And by all implication, even by virtue of even this order stands,
Lordship.
the land acquisition process did not get vitiated.
No, I'm deeply obliged and also.
I believe this is your
absolutely.
Main contention, I
Yes,
believe, in this case.
And I'm deeply obliged, and also that the authority has also not cancelled the acquisition.
So the acquisition proceeding remains unaltered.
I'm deeply obliged. Yes.
Despite the fact that it has been recorded wrong.
No,
I believe it is your.
Yes, that is correct, but the recording is also not by the DLL or the authority, appellate authority, is not that the land acquisition has been cancelled. He specifically records that the recording in 1994 has been rejected.
That I understood.
Lordship.
But so far, but it does not, it nowhere touches
the acquisition proceeding. He cannot, because once it has been acquired as possession handed over by lordships have held time and again, he cannot.
This is a very, very short and concrete submission on your behalf.
I'm deeply obliged.
Anything more?
Yes, my lord, I will only for 2 minutes rely on the affidavit filed by the state government.
Yes, sir.
My lord, that has been filed by one Mr. Humayun Kamar. Humayun Kamar.
If he is in opposition, no?
And also one more point, my lord, subsidiary point, which, my lord, I have taken that, my lord, the petitioner possibly does not have a locus to file the petition. Because as of now, how they derive their title from the sale or the sale.
That you have submitted.
Lordship. Now, my lord, kindly takes this affidavit by the state government.
Give me a second.
I'm sorry.
Let me search.
তার আগে তো আমি জাজমেন্ট আমি তো দেবো
Yes, affidavit in opposition of the
State
land
government.
acquisition collector.
Lordship.
It has been affirmed by Mr. Humayun
Kumar.
Kumar.
Right. I'm deep. Now kindly takes page 4.
করলেন এই তোমাদের না
Page 4 once. My lord.
affidavit in opposition of the state.
Lordship.
Page 4.
Lordship. My lord, page 4, the first paragraph is, my lord, the states relies on the section 6 notification, which I also annexed in my affidavit. That is
Yes.
at page 8 of this affidavit. The same notification under section 6. That whereby my lord, plot 1800 is acquired in full. That is page 8. That is also I have annexed. Now then kindly see. Subsequent thereto, the possession of the entire CS plot number 1800 along with others were made over to the executive engineer construction division road between such and such. Now my lord kindly turns to page 9 of the opposition. Page 9 is dated 16th June 1966. To the executive engineer road construction division Midnapur. Kindly note the subject. Acquisition of land for the construction of approach road is to temple from Diga Fort Shore. Now, my lord, kindly sees right at the bottom, clause number 3. As regards the following areas, they have been acquired in the case noted against them, and possession they should therefore be taken from the department to which the possession has been delivered by us. Kindly sees RS plot, the second plot 1800 in full. Kindly see the remarks. Possession of the entire plots made over to the executive engineer construction division between such and such in Act 1 in LKS of 16. So 1800 acquired, handed over, of possession handed over to the road construction division Midnapur. Now, my lord.
Yes, just a minute.
I'm sorry.
Yes.
Now, my lord, kindly takes page 5 of the affidavit. From the second paragraph. From the draft records available to the department, it also transpires that the total land lying in plot 1800 was made over to the road construction division. Now, this is R3. Now, that kindly turns to page 11. Now, this is very important. Page 11, lordship straight away turns to page 12. Now, kindly sees the left-hand column.
All the 3 Bata plots have been?
Everything. The total area of the plot 2.4 as per ROR, the same is made over to the construction division, including the Bata plots. Now, my lord, the last document kindly sees. When again, if your lordship again takes the trouble to come back to page 5.
Sure.
Now that next paragraph, that apart from the extract of a plot index register lying with the department, it further transpires. Then the entire plot 1800 has been acquired by daily case number 55 or 56. Now, my lord, kindly takes page 13. That is the last document.
Yes.
Not the, I'm sorry, again in the middle, the 11th number, my lord. If your lordship, page 13.
Huh.
My lord, it starts with 1659 at the left hand column.
1800 is
1800. Kindly sees, my lord, what it says at the bottom, where the right hand column, the entire area of 47.47 acres acquired, Act 1 of LA case number such and such a 5056 by construction division, 2.44 acres above case on entire plot acquired, entire plot. Now, today, by my learned friend's case is now that after everything has been done, acquired everything, no complaint ever raised with regard to compensation. Now, on the recording done in 1996, a judgment passed by this honorable court on the basis of non-production of documents by us before the court, on the basis of 84 recording, saying that it appears that it has not been acquired. The appellate authority, on the basis of that, holds that he proceeds on the basis of that, and by judgment of Justice N.K. Mitra, proceeds on by holding that no, it appears that it has not been acquired, so therefore it is cancelled. Today, even if it was done, but I will not repeat myself, the acquisition cannot go. Vis-a-vis, section 16 and 17 of the Land Acquisition Act. Now, kindly takes section, I'm sorry, yes, 16 and 17. I'll just place it. But I'm handing it over to your lordship. So, what's the copy? Council. Well, kindly takes section 16 and 17. This is the power of taking possession and how it is. In my actual submission, my lord, once the possession has been taken and handed over, well, it cannot be travelled in this way, cannot be changed. And by virtue of a writ petition, wherein the prayer is that you do not enter into my premises and dig. Unreported judgment 2021 SCC on.
So vesting is complete.
And he is a post-vesting transferor. Whether the transfer at all lies, possibly one of the reasons were in the Bikroy Kobala, no precedent has been stated. Now, my lord, I'm relying on two judgments. I'm not trouble with lordship. Every paragraph.
Why should I?
Now, this is 2021 SCC online, Supreme Court, page 802. Well, I'm just reading and giving my copy to my learned friend.
Yes.
And kindly takes paragraph 6. 6 to 9, very short paragraphs. Kindly takes paragraph 6. It is not in dispute. I'm sorry, my lord, kindly takes it.
Yes, sir.
It is not in dispute that the dispute is with respect to mutation entry in the revenue records. The petitioner herein submitted an application to mutate his name on the basis of alleged will dated such and such. Even according to the petitioner, also from the record, it emerges, these are not important, it emerges that the application before the Nayab Tehsildar Maisonetto, that is before the date of the, it cannot be disputed that the right on the basis of the will can be claimed only after the date of the execution. Even the will has been disputed. Be that as it may, it is the settled proposition of law. Mutation entry does not confer any right, title, interest in favor of the persons, and the mutation revenue record is for fiscal purposes. Now, my lord, kindly takes paragraph 7. It relies on a case called the court had an occasion to consider the effect of mutation. It is observed that held that mutation of property in revenue record neither creates nor extinguishes the title to the property. Only for this. So, this I was actually relying on to show that it has been muted, it does not create any title. But the main decision, my lord, I will refer to your lordship. My lord, this is my lord 2020, volume 8, Supreme Court cases, page 129. This is my Indo Development Authority case. 2020, volume 8, Supreme Court cases, page 129.
Will you please repeat this?
Yes, of course. My lord, 2020, volume 8, Supreme Court cases, page 129. Yes. Kindly takes down the paragraphs also.
Page 129.
243, 246, And 243, 246, 255, 256, 258, 259 and 279. चलो बोल दो।
129.
Right. May I just place it? I'll copy नहीं रहे? Madam, I'm sorry, Madam, I have one copy.
Read out.
Where's paragraph 243? It is clear that once land is acquired, award passed and possession has been taken, it has vested in the state. It has been allotted to beneficiaries. A considerable infrastructure could have been developed and the third party interest had also intervened. Same here. The land would have been given by the acquiring authority to the beneficiaries from whose schemes the land has been acquired, and they have developed immense infrastructure. We are unable to accept the submission that merely by deposit of amount in the treasury of the court we should invalidate this. We are also not able to accept the submission that when law operates, these harsh consequences need not be seen by the court. In our opinion, the submission is without merit and the consequences envisaged. So, my lord, this paragraph in my submission says, once it has been acquired, possession given, third party interest created, not even if ordinarily the facts ensure so, warrant so, it should not be effective. Now, my lord, kindly takes paragraph 246.
So your bone contention would be, I believe, that since the land acquisition has been completed, the property in question has been vested,
Possession
the
given.
petitioner cannot take advantage of the wrong recording in the R1.
Deeply obliged. And
it should be, according to you, it should be in Khotiyar number 1. But for some reason or other, it cannot be done. Even then, it does not make the acquisition proceeding invalid.
Number 1 and number 2 has not challenged that also. His prayer is limited.
That we have submitted.
And paragraph 246, I will not trouble your lordship by reading. I have sent it. But these the remaining paragraphs will deal with section 16 and 17 of the Land Acquisition Act, saying, again reiterating that once in details that once it has been taken as has fallen from your lordship right now, the court should not interfere.
Right.
Those are my submissions.
Mr. Siddiqui, would you adopt the submission or you will make
No, he is the acquiring authority. I will adopt his.
I have some added submission to make.
Very good. Make your submission.
Bolo.
My lord, from where Mr. Bihani left, I will start from there.
Excellent. My lord, if your lordship allows me, because I have to, in the bar library, I have to, the two juniors are waiting, I have to surround their lodgences, otherwise their admission will not be done. What are the, my lord, my juniors will be here.
Sure.
I'm sorry, my lord.
No, it's all right.
Lord, I would commence from where Mr. Bihani left, my lord.
Yes.
My lord, at the outset, my lord, I think, my lord, Mr. Bihani has submitted that what is the scope of the writ petition, the relief sought in the writ petition. The relief sought in the writ petition is with regard to illegal digging of the land, to remove the trespassing of the land, which is the relief, my lord, which cannot be sought in the writ petition, because, my lord, those are all the reliefs which can be filed
under the specific relief
act.
Before the common law forum.
Common law forum.
So alternative remedies available.
Number 2, my lord, Digger Development Authority, Mr. Bihani appeared for the authority, had requisitioned the land as pointed out by Mr. Bihani long time back, and thereafter this land was given to different authorities. There is a bank, there is a post office, they were given to different authorities. Everyone is well aware about that. The petitioners can see from their open eyes those authorities. They have not been implicated as a respondent. Number 3, after making this pleading in the writ petition that the lands are being dug up, third party rights are being created, the petitioner has sought to improve his case by filing an affidavit in reply saying that this acquisition itself is bad, and his entire case is founded upon the order passed by my lord Justice Barin Ghosh as his lordship then was. This entire case is founded upon that, my lord, nothing more, nothing less, my lord, because the land was acquired.
And another order passed in the appeal. Another order has passed in the appeal.
No, my lord.
Whereby the recording has been cancelled.
No, my lord. My lord Justice, my lord rightly pointed out Mr. Bihani, my lord Justice Ghosh was not made aware with regard to the acquisition being made complete. Well, I'll not trouble your lordship with all the documents. Acquisition being made complete in all respect. Section 16 of the Land Acquisition Act specifically says once the land has been acquired, compensation has been paid, possession has been taken, compensation has been paid, the acquisition is complete in all respect. The land is vested to the state. But after vesting that land, we have given it to the requiring body. This fact was not brought, my lord. Some of that was not brought before my Lord Justice Ghoshmada, as his lordship then was. Subsequently, prior to that, there is an order of my Lord Justice N.K. Mittal, my lord. Based on that, a proceeding was initiated by the authorized officer under section 54, subsection 3 of the Land Reforms Act. That proceeding did not culminate into any final order. They preferred an application before the learned Land Reforms and Tenancy Tribunal, challenging that the authorities have not corrected the record of rights based on the order passed by my Lord Justice Ghosh. That is one aspect of the matter. The authorities took no step whatsoever. They did not took any steps with regard to the orders passed by my Lord Justice Ghosh, or that the orders passed by the authorities sitting tight over the order passed by the SDLRO, directing the authority to take steps for correction of the record of rights. That is one aspect of the matter. With regard to correction of record of rights, no steps taken. Now they filed this writ petition. This writ petition, my lord.
So far as the order passed in the by the BLRO and appellate authority, they have approached before the appellate authority. The appellate authority set aside that order.
No, appellate
directing
the BLRO to correct
the record of rights.
BLRO did not take any steps. They filed an application before the Learned Land Reforms and Tenancy Tribunal. Lordship kindly sees the reply. But Lordship kindly comes to page 19 of that reply.
Reply to
their reply. To
they have filed two replies, I believe.
Their affidavit in reply to the affidavit in opposition filed by the respondents, my lord. The heading is affidavit in reply of the writ petitioner above named to the
30th July 2018.
30th July 2018.
Hemant Kumar Mishra.
Yes. 30th July 2018.
Yes.
I'm grateful, my lord. To page number 14, my lord, which was 20, your lordship, is the order passed by the officer empowered under section 54, subsection 3.
That is the appellate authority.
That is the appellate order. The order is dated 10th of January 2008.
10th of January 2008.
No steps was taken by the BLRO pursuant to the order passed by this appellate authority. Challenging that, they filed an application before the Learned Land Reforms and Tenancy Tribunal. The order is at page 19. 20th July 2010. But questioning the inaction of the authority.
Does it create any right in favor of you?
No, it does not create any right in favor of them, my lord. Today, my lord, we are concerning a writ petition which has come up before your lordship. But I am on. This is one aspect of the matter, that they have not corrected any record of rights. They have not done anything with pursuant to the order passed by my Lord Justice Ghosh. And the other aspect of the matter today is the relief sought in this particular writ petition. Today in this writ petition, my lord, the relief which they have sought is specific. It has been shown.
It has been shown.
To stop illegal digging on the land.
What I am on, by the appellate authority passed an order, thereby set aside the order of the competent authority before which you raised your objection. And it was directed by the appellate authority to BLRO to initiate a proceeding under section 51A within bracket 4 suo moto to effect and pass a resolution order after affording just and fair opportunity. That is recording
for correction of record of rights.
Be that as it may. Question is that what the learned counsel appearing for the petitioner contends that by this order the recording has been held to be right. The actual recording has been held to be right, and LA proceeding has practically been vitiated, which has been disputed by Mr. Bihani as well as by
my lord, first of all, my lord, mutation does not confer any ownership. Whatever is recorded, my lord, the law is well settled. Mutation does not confer any ownership. But with regard to the question which falls from your lordship, my lord, I'll tell you.
Appellate authority
held.
It is therefore crystal clear the suit land were never occupied in acquired in LA case number such as such. I believe it is your contention that these appellate authority cannot hold this. Come internal page number 14.
Internal page number
4. I'm sorry.
4.
Read the middle portion.
It is therefore crystal clear that the suit land are not acquired in LA case. Though the suit land were recorded in favor of Diga Development Authority in objection case number this of this. Well, the appellate authority.
No, read the upper portion.
The upper portion.
Read from the top.
This is most vital issue as to whether the land has since been acquired or not. In the disposal of the objection case number so and so under section so and so of Mosa so and so GL number so, it was held that the suit land has been acquired in a land acquisition case number so and so, but it is evident from the judgment in WP number so that the land in question were not acquired. Not only that, but also from a memo number so and so, LA collector, it is learned that plot number so and so for an area of so and so and area of so and so were not acquired in the LA case number, though these plots were involved in the aforesaid LA case at the initial stage for acquisition. My lord, this is the recording observation of the authority under section 54 subsection 3. That is what I was on.
According to you, I believe it is beyond his scope.
My lord, it is beyond his scope.
But you have not you have not challenged that.
We do not, my lord, we did not, because he cannot correct the record of rights. He can correct the record of rights, but he has to send it back to the BLRO for correction of record of rights under section 51. Now, my lord, the BLRO took no steps for correction of record of rights. Questioning the inaction of the BLRO, he approached the learned tribunal. Tribunal directed the BLRO to consider the representation and pass a decision order. Nothing was done. Now, my lord, he has come after this order.
Nothing was done.
Please take your seat. It is very unparliamentary. Yes, Mr. Jadiki. Please proceed.
Now, my lord, in 2000, after this order passed in 2010, my lord, he sits tight over his right. He filed this writ petition in the year 2017, saying that
I understand your contention. Please reply to my question. How do you want to overcome the finding of the appellate authority for which you have not preferably happy? That I want to know.
My lord, the appellate authority's finding, my lord, is only with regard to recording of rights. The appellate authority.
This is submission of Mr.
The appellate authority subject to correction cannot say with regard to acquisition, my lord. There are two aspects of the matter. One is acquisition and other is, my lord, recording of rights.
So it will not operate as a res judicata.
It will not. My lord, subject to correction. My lord, it will not. My lord, your lordship will kindly acquisition is completed in all respect long time back during the 1960s.
That is within the domain of the LA collector, not in the domain of the appellate authority or the PLR.
Now, my lord, whatever has transpired is with regard to recording of name. Even if his name would have been recorded.
I believe I have understood your submission. Actually, Mr. Bihani argued on that.
We have filed a written notes of argument in this regard. But a long time back, it is there in your lordship's file.
Usually I do not take any written argument because I take extensive note.
My lord,
I would have pointed out. Now, my lord, I would have, my lord, placed reliance upon 2 or 3 judgments, my lord. If your lordship, because it's going to be 2 o'clock and returning your lordship.
No, it's all right.
My lord, just 1 or 2 judgments.
Yes, sir.
My lord, this acquisition took place long time back. One is, my lord, 2018 volume 3 Supreme Court cases, page 588.
2018 volume 3 STC,
page 588.
Very good paragraph.
My lord, paragraph is 23 to 26 and 29.
Paragraph
23 to 26
and
29.
yes.
Now, my lord, paragraph 23, I will not trouble your lordship with the entire paragraph. Paragraph 23 at page 602 at the bottom.
Yes.
My lord, in the instant case, my lord, we are in 2017. Lordship may kindly, my lord, your lordship may kindly note that 2017 this writ petition has been filed. Acquisition is completed in all respect in 1960s. In the instant case, the claim has been made not only belatedly, but neither the petitioners nor the previous three generations had ever approached any of the authorities in writing for claiming compensation. No representation has ever been filed with any authority. None has been annexed and there is no amendment made in the petition. The claim appears not only stale and dead, but extremely clouded. This we are mentioning as additional reasons, as such claims are not only suffer from delay and latches, but courts are not supposed to entertain such claims. Besides, such claims becomes doubtful, cannot be received for consideration, being barred due to delay and latches. And my lord, paragraph 27. The prayers that have been made in the writ petition are not only misconceived, there is an attempt to stop the ongoing construction activity. It has also been mentioned that government offices, etc., have come up and the government has leased property to private parties also. But still, the prayer has been made to stop the construction activity. It passes comprehension how such relief could ever be asked for. No authority had ever been approached by the petitioners or by the ancestors. As such, the petition is aimed at the total misuse of the process of law. Even for a moment, such a petition could not have been received for consideration, and thereafter it was dismissed with cost. Now, this is one. Other is the Indo Development Authority's judgment. I will be relying upon page. What was his judgment? 2028 SCC, page 129. I will be relying up 2020, volume 8, Supreme Court cases, page 129, paragraphs 335 to 339 and 356.
Three 335 to 339 and 356.
And 356. Not only the last paragraph, my lord, I'm just placing it before your lordship.
356.
356. But I'll not trouble your lordship with the entire paragraphs. We are of the opinion that courts cannot invalidate acquisitions which stood concluded. No claims in that regard can be entertained and agitated as they have not been revived. There has to be legal certainty where infrastructure has been created or has been developed partially and investments have been made, especially when land has been acquired long back. But in this case, land has been acquired in 1960s. All buildings have come up.
Yes.
Today, my lord, after this new act of 2013 has come up, everybody is, my lord, jumping on their feet because they want to seek compensation under 2013 Act. That is what the Honorable Supreme Court has said. It is the duty of the court to preserve the legal certainty as observed in Vodafone International Holdings. The landowners had urged that since the 2013 Act creates new situations which are beneficial to their interests, the question of delay or latches does not arise. This court is of the opinion that the said contention is without merits. This court is of the opinion that as held earlier, the doctrine of latches would always preclude an indolent party who chooses not to approach the court or having approached the court allows an adverse decision to become final to re-agitate the issue of acquisition of his holding. And my lord, this all entire acquisition took place long time back. The petitioners before your lordship are post-vesting purchasers. Thank you.
That's all.
Well, that, my lord, I believe, my lord, Mr. Vyani also shown to your lordship that this was CS plot number 1800, which was bifurcated into butterflies.
So, madam, you please hand over the photocopy of the, just a minute, 2020 volume 8 that Mr. Bihani has not handed over. 2020 volume 8 SCC 129 and Mr. Siddiqui. Oh, you both of you referred same judgment.
2020, then my lord, I have given that 2018 volume 3 SCC 5858.
That you have handed over. Any of you hand over the 2020 volume 8. Very good. Give me.
2020 is a very big judgment, my lord. It's around 500 pages.
Very
The
good.
book is required.
No, not required. I have also SCC online. Even then, I am keeping this book.
My lord, reply, my lord.
What reply, sir?
My lord, reply. Otherwise, I'm under your court judgment, my lord, declared by my senior friend, my lord. My lordship, kindly fix the date tomorrow.
No. Conclude today.
Or 2:30.
No, sir. No.
Just know that judgment we have to read, my lord. Otherwise, my lord, lordship, kindly the big matter, my lord. Lordship, only the big itself, lordship.
Copy has been given this much.
No. Copy, my lord. Only that in the judgment, not copy has been given, my lord. Not the lordship, kindly.
Take this book.
It's not possible for me, my lord.
No.
No. Please sign me. Please sign me. Phono aage.
Also, land posted, madam, which is supplement of the my lord, we have applied in the year 1996 for the government of West Bengal. My lord, after considering our application, my lord, the government of West Bengal allocated plot for some plots of land. Where our branch office of the bank and we set up. But kindly see the team, but I have annexed by my application.
Right, all
No, sir.
For reply, my
No time.
my lord, lordship, kindly, sir. I want to.
Just a minute. Let me listen. Application or appear in opposition. That has been allowed.
Yes.
Then you have filed any affidavit in opposition. Then why should I look to that? You adopt his argument. That's this much.
I've been added by adopted.
Very good. Mr. Siddiqui has said land acquisition has been taken place for a long back, and in the meantime, third party interest has been created. So it should not be disturbed. Is it your submission, Mr. Siddiqui? Yes, sir. Reply.
That the land in question still in our possession, in my possession. No third party interest.
That you have got.
Second submission, my lord, regarding prayer A, giving the plot. But at that time, my lord, Kovaladori with me, record of right with me. So I.
Mr. Chatterjee, so far my knowledge goes, reply on the point of law is permissible. Reply on the point of facts is not permissible.
Then, my lord, what we kind of look into page 9. Page 9 of evidence in opposition. No estate acquisition act proceeding was started, relied by landlord senior friend. Kindly have a look into page 9. First, I also noted 470 under section WBLR Act 1955. Very interesting point. They relying upon that document. My lord, 55. Not only that, for correction. And thereafter, kindly come to my reply page. My lord, page 14. My lord, their reply. Penultimate paragraph. I am not wasting your time, my lord. My lord, penultimate paragraph. It is ordered that the order passed by the landlord revenue officer in objection case number under section 51A subsection 1 being number 417 is hereby set aside. All entire case is set aside, not the mutation. And not only that, my lord.
Hearing is concluded. Judgment is reserved.
Grateful.
My lord, no acquisition, nothing, my lord.
Before rising, your lordship.
Only one paper. We have shown
Yes.
that is not the acquisition, my lord.
Very good.
My lord, before rising, item
Concluded, sir.
my lord, item number 1, your lordship please to fix tomorrow at 10:30, my lord. But my lord, tomorrow, my lord, I have a continuing part at matter before the Supreme Court, Justice Honorable Bela Trivedi, my lord. Kindly fix the matter on Monday 10:30, my lord.
I will inform
Then
Mr.
it-
Abbasuddin and Mr. Meklas.
No, it will be at 10:37.
My lord, I have a continuing part at matter, my lord. I have a continuing part at matter, my lord.
Oh, it should have been made at the time when they mentioned.
My lord,
I mentioned it.
my lord, I will kindly fix on Monday, my lord. I will inform, my lord.
Ask any of your friends to seek accommodation.
Before rising, lordship.
All relating to fair complaints, I am not paying compensation.
I will check. I'll consider.
Lordship, before rising, lordship, kindly.
My lord, this is my application, but my lord, there is a technical difficulty in taking up this, my lord. Why I am saying this is something, my lord, which was filed initially. Subsequent to that, my lord, during pendency of the writ,
What
my
is the
lord,
application for?
my lord, this is this is a writ application, my lord. My lord, for correction of the records and fixation of the assessment amount in line with the order which has been passed by the tribunal. But my lord, when we filed this, my lord, municipality took a leave. And my lord, they had filed a subsequent civil revision, my lord, which was also pending. So it was the coordinate bench held that since this is something which is to be done fast, so let the civil revision be done with, and thereafter this will be taken up. In the meantime, my lord, by an order dated 7th of November 2024, my lord, both this matter was directed to be tagged together so that it can be finished off. Now, my lord, since it was being heard out by different benches, because that is also ready for hearing. Now, my lord, this was the order. I may hand up this order to your lordship. Based on this, my lord, based on this, my lord, we had actually, we had made an.
So far as item number 1 is concerned, it is showing only WPO along with CO. There is no mention.
No, so my lord, we had actually made.
But in the order itself, when the matter went before the office of the Chief Justice, the order speaks of that these matter and also the CO matter to be heard together.
So, my lord, what we had done, we had written
Give
to
me a
the
second,
registrar.
Give me a second.
We had the order to
In the representative petitioner
my lord,
paid
we had
for
written to the registrar.
implementation of the so writ petition was filed for implementation of the order passed by
Yes.
the Kolkata Municipal Corporation challenging a preferred repressive evaluation. It for the FSO case and case is connected interest of both matters are required to be heard by the present petition is released from the So why is the order of the Honorable Chief Justice regarding the assignment?
My lord, what has happened? We had made an application before the registrar original
I
side.
got it, sir. I got it, madam. Release from management. So why is the CO? So why it is not listed with this CO?
You also assign, that we do not know, you find to know.
Both are assigned, my lord.
Yes.
Then in that even very well, my lord, fixes the date, my lord. Immediately after vacation, we shall come and finish it.
All of you, please sit.
Because I find in the
all of you see
no,
the
no,
endorsement of
that
the
may
order.
be in the list matter only the
So that
should have
is
been-
why.
should have been. So
Yes.
that's all right.
My lord, that is what we were actually worried.
Hey, দেখান ভাই কথা বোঝেন না বাংলায়
ঠিক আছে
My lord, perfect, my lord, perfect. Then
after the vacation
fixes the date after vacation, we shall come and argue the case.
Come, কে লিখবেন?
list.
No, there is a defect in listing.
ভুল হয়ে গেছে। ভুল হয়ে গেছে।
Are the learned advocates for the parties This one.
My lord, I was not saying the effect in the application. My lord, I said there is a technical difficulty because both were supposed to be tagged together.
So that has
Now,
been,
since,
that
yes,
is,
yes, yes, my lord. Since already that is the administrative order, so all our grievances are over.
very good. Call the next man.
না না ওটা একসাথে ট্যাগ করে দিচ্ছে এখন মাছ oblige হলো হুম না না বলছি সিওটা একসাথে
One, two, three, four, 5 read petitions are there.
Yes.
There are
Well, let four read
four read petitions by
the occupiers.
the occupiers, including one in the original side and three in the appellate side,
Yes.
and one read
by the
petition by the developer who has already suffered a crippling blow. He has lost in the matter where the sanction plan obtained by him has been quashed by this honorable court. To the best of my information, I appear on behalf of some of the occupiers. There is no appeal, my lord, from that order.
Give me a second, sir. Any interlocutory application is pending?
One in the
Can
appeal
one?
by the developer.
Can one is for what?
Cannot developer it. Developer matter.
Can one?
Yes, I'm just checking.
In respect of that writ petition, my lord, which numbers 1811 of 2022.
1811 of 2022.
Yes, my lord, but that in that petition, my lord, my learned senior is appearing. I am.
Well, other four matters. That is Monisha.
Can one key just
What can right
That
now,
I want to-
suddenly this matter come up by
Hey, এটা
so
দেখাও।
I am actually
suddenly
এই can one টা কি আছে দেখি can one of 2022 টা যদি ওর স্টে থাকে আলাদা করে
management থেকে কিছু বলতে
এইটা one
এই পেজ is can one page
হ্যাঁ খুঁজছি আমিও খুঁজছি
so one in original side and 4 in appellate side.
four in appellate.
All are identical matters.
Connected with the same premises, the same transaction.
সেগুলো কোথায় পাবো? আমাকে ক্যানটাকে বার করো এই ক্যানটা কি আছে দেখে নি আর চারটেরই ফাইলের চারটে রিট পিটিশন বার করে দিলাম চারটে
সিনিয়রকে দড়ি দিয়ে ঝুলিয়ে দিল
ওগুলো দেখি
পড়ে এসছো
in all the read petition exchange of affidavits are complete.
Yes. We have filed our affidavits in all the read. Only in the can there is no exchange.
But regarding my writ petition, opposition has been given by 1811
So far as
of
WPA 1811 of 2022 is for
opposition. I am for the corporation. Opposition has been
is
given.
for the petitioner.
Petitioner.
Mr. Sheikh developers.
Yes, Sheikh Developers is the developer. He's not here today.
Who is for the petition?
The advocate was Mr.
Shaunak Mondal, advocate on record.
Yes, they are not present here, my lord.
ও তুই 1811 এ নেই
1811.
This is for expeditious hearing. This is for expeditious hearing. আচ্ছা এবার আমাকে এবার দিন তো 1 by 1 আপনি আমাকে প্রথমে দিন হচ্ছে WPO 1944 এর WPO টা দিন আমাকে কি আছে
194.
এইটা WPO 1944. It is whose writ petition?
But may I just indicate, my lord, what has happened?
What is your prayer here?
Kindly look at the prayers. That's at page 28 of my lord's brief.
Cancel, rescind, revoke the purported notice under 411 in respect of 26 Budu Ostagol Lane. So it is a notice of demolition.
There's a notice of repair and or reconstruction under section 411. This is not unauthorized construction. This is the dangerous building section 411. That notice was served. The entire transaction, my lord, which would appear from the writ petition
was tainted, my lord, by collusion. We are the occupants. We were not served these notices under section 411 initially. Subsequently, my lord, the developer entered and forcibly tried to pull down our buildings. That is when we.
Where is the notice?
Now, if your lordship kindly sees, this notice, my lord, we have not received. যে তোরা এতে দিয়েছিস তো, এটা অপোজিশনে দেয়। হ্যাঁ, এটার মধ্যে Lord, may I suggest something to your lordship? If your lordship does not take me amiss, I am otherwise ready to do the matter. There is no difficulty. I thought, my lord, if I make a comprehensive list of dates, might be easier for your lordships.
No issue, but let me ascertain whether the exchange of affidavits are complete or not. So far as original side writ petition is concerned, WPO 1944 of 2022, exchange of affidavits are complete. Let me check it. Affidavit in opposition, affidavit in reply, exchange of affidavits are complete. দাঁড়াও, আমি একটু নোট করে নিই ভাই, আমার একটা সিনিয়র
এই গালাগালি করিস না, পাইতে যেতে। থ্যাংক ইউ। আজকাল লোক
very good.
My lord, there is no way, my lord, in which the air conditioning of this room can be operated at a high temperature, because most of my friends at the bar are saying that it is
I am also feeling
very suffocated. I am obese, so I tend to perspire.
Absolutely.
There is some, I think, some discomfiture around.
I am also feeling discomfort. Okay, now give me the file of WPA 1811 of 2022.
That's correct.
Who is for the petitioner here?
1811.
Huh? Petition, affidavit in opposition, scan, no? Okay, application, affidavit in opposition. It can affidavit in opposition. No affidavit in reply has been filed.
লোক পৌঁছাতে হবে, ওটার সঙ্গে ওগুলো ওদের মিলে যাচ্ছে।
দেখি ওটা কার আছে। ওটা কার আছে বলুন তো রেসপন্ড। One, two, three, and 4. No reply.
Reply.
No, ওটা লাগবে না। এক্সেপশনটা তো ওদের ক্লিপটা দেখে নি একটা প্লেয়ারটা কি আছে। Have you got any idea, though the learned advocate is not appearing in WPA 1811 of 2022, The same notice is impugned?
The same transaction is in issue. 411 notice was issued by the corporation. Same building.
Quashing the notice at 11/1/2022.
11/1/2022 must be, yes, for I'll just check the notice. I actually didn't receive the notice, so I've just mentioned it by date. That's what this is the notice of 2020. There's a series of acts that have taken place, but all this is in connection with the same
Very
transaction.
good. In this way, no reply has been filed.
No reply.
Hmm?
ডাইরেকশন কি মনে পড়ছে এভিকশন রিমান্ডের পর যখন এলো
ভেরি গুড, আমি দেখছি ওটা, এটা রেখে দিন আপনি, হয়ে গেছে। নাও ধরুন ধরুন ধরুন। So far as the WPA 834, 835 and 838.
Here I
exchange
don't
of
think-
evidence are complete.
No, 834, 835, 838 were
It is yours.
disposed of. Yes, they are mine. They were disposed of. We filed an appeal because the other prayers had not been taken into consideration. The Honorable Division Bench remanded it back for consideration of 2 additional prayers.
Prayer B and prayer D was the prayer that were to be considered now in this 3 petitions.
Now, therefore, my lord, on this, my lord, I do not find from the record that any direction for exchange of affidavits has been made. I would say.
What is the order of the appellate authority?
The appellate court's order. এটা হ্যাঁ
What is the order of the appellate authority?
We're trying
Or appellate court?
to lay our hands on.
So far 834 is concerned?
Yeah, there were similar orders sending back these writ petitions back.
Show me the
yes,
order,
I'll
sir.
have to show. Yes, yes.
So without perusing that order, I cannot direct for exchange of affidavits.
Unless, yes.
What type of order has been passed by the Honorable Division Bench?
It was an open remand, but on 2 prayers. So, and there were no affidavits exchanged when the matter was first disposed of. But yes, your lordship will have to look into that order. Without that,
Then read your act upon implementation. There you have prayed for cancellation. Now here for the implementation of the notice.
now, my lord, I'll tell you, lordship, my lord, the 411 notice was there for repair. Now, apart from the repair, there were certain other aspects that were brought into the writ. the honorable single bench only passed certain orders and did not consider the two other orders regarding quashment. So that's why the matter went up to the division bench. I think if I can show you a lot of the orders that we held, but unfortunately, no, today I'm ill-equipped. All the things over.
Take down. I cannot wait.
No, yes.
Hard land.
ও এ দুটোতেই আমরা ঠিক আইদার পিটিশনার আর রেসপন্ডেন্ট দেখে নিও তো বলা আছে ইন ডব্লিউপি ওতে আমরা রেসপন্ডেন্ট ডব্লিউপি এতে আমরা অ্যাপিলেন্ট
এই লিস্টটা চলে গেল লিস্টটা চলে গেল
হ্যাঁ 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 আছে দেখবি ওই পিটিশনের
লিস্টে চলে গেল গো
একটা order করে দাও। আমি অর্ডারটা দাও আগের অর্ডার গুলো দাও আগের অর্ডার গুলো দাও দেখা লেখা আছে
কল দি নেক্সট ম্যাটার
আমি আগের অর্ডার
ফাইলটা দিন না ফাইলটা দিলেই তো উনি বুঝতে পারবেন ওনার ক্লায়েন্ট কি
earlier option it was recorded for whom or I am
নো নো অন দ্য আর্লিয়ার অকেশন ইউ আর নট দেয়ার
people might have seen Sarkar
দ্যাটস প্লিজ চেক এই লিস্টে চলে গেছে বাবা একটু দেখো না খারাপ পেতে শুরু করে অ্যাপ্লিকেশনটা কোথায়
Second number 3.
1811 check whether you are there or not. Call the next matter.
Number 3.
But I am for the writ petitioner, but there is a GA which is pending in this application for amendment of the writ petition. Now, my lord,
Where is the GA?
My lord, GA should be before your lordship. GA number 1.
I don't know.
Now, my lord,
GA1, where is GA1? It is GA1.
I have already filed my affidavit in opposition.
yes, my lord, the private respondent has already filed. My lord, repeated occasions where chances were given to the Kolkata Municipal Corporation. They have forfeited they have not filed and they have forfeited their right to file any affidavit in opposition. But kindly takes up the main GA.
Well, I submitted to Rashimara so far as the amendment application is concerned.
What is the proposed amendment, sir?
Yes, my lord, kindly, my lord, come to my lord.
What are the
You don't give any schedule. What is the practice in the Saudi side? Schedule of amendment or
Annexure H, page 56.
annexure?
H, page 56 of the application.
What is that?
My lord, the entire, my lord, writ petition along with the proposed amendments kindly come to page 63 of this proposed amended writ petition, page 63 onwards. Kindly see 19A, 19B, 19C, 19D. They are all underlined. And my lord, these are the proposed, my lord, amendments. I will indicate to your lordship why this amendment is required.
Main writ petition টা দেখি একটু main writ petition affidavit in opposition টা
But may I indicate to your lordship what is the
Give me
main?
a second, sir. Let me see what is your prayer and what amendment you have sought for. দিন affidavit in opposition টা দিন। It is for cancellation of the sanction.
My lord, the original writ petition was cancellation of the sanction plan.
Yes.
What has happened is during the pendency of the writ petition, and despite a report being filed by the corporation that certain portions have been illegally constructed, they have, my lord, gone ahead to the corporation and have obtained a revised sanction plan. So, my lord, now I am challenging not only the original sanction plan but also the revised sanction plan, and all that has happened during the pendency of the writ petition before
So
this.
these are all subsequent events.
Subsequent events, my lord, I could not have been, my lord, brought before your lordship at the time of main filing of the main writ petition. And my lord, during the subsistence of the writ petition before your lordship, my lord, this has been done. My lord, kindly see, my lord, what I have pleaded, what I am trying to incorporate, page 63. Page 63, my lord, 19A. This is the first time, my lord, I have stated, however, in terms of the order dated 9 January 2020, the advocate for the respondent number 6, for the first time handed over a copy of the revalidated sanction plan, a copy whereof along with the order dated 9 January are annexed. Then, a bare perusal of the said revalidated sanction plan would reveal that the purported plan is not a mere revalidation simpliciter, but in fact a revised sanction plan which includes a portion occupied by the petitioner.
So, why in the event it has been handed over to you in the year 2020, what prompted you to file it in the year 2023, sir?
My lord, page 54, kindly sees the order. Page 54, first of all, I have taken refuge behind COVID and my lord, several rounds of my lord, negotiations were also going on. Kindly come to page 54, the order of Honorable Justice Aniruddha Roy.
In 1920, I believe there was no COVID.
No, 20, my lord, 20, my lord, kindly see what is the date, January 2020, and my lord, March it started. Your lordship knows the harrowing times. January 2020, the plan was handed over, and my lord, we were hit with the pandemic from March 2020.
Who is appearing on the respondent?
My lord, only one more minute, my lord.
I will hear you.
Yes, my lord. Because the law is
If-
very
if
clear
they
that
say I will hear you.
amendment has to be, my lord, allowed, and a liberal approach has to be taken by the court. My lord, and my lord, that the merits of the amendment cannot be gone into at this stage. It can be decided by your lordships.
Exchange of affidavits are complete.
Yes, my lord. The private respondent has filed, and my lord, we have filed our reply, my lord.
Kindly take your lordship's amendment application.
Lordship is only to consider today, your lordship, whether the nature and character of the repetition is changing or not. Today, your lordship, the revised sanction plan, which has already been given effect to, that your lordship has been challenged by filing this amendment application, your lordship, in this writ petition. If your lordship kindly takes the prayer in the proposed writ petition, what was the original writ petitioner and what your lordship you have challenged today. Your lordship kindly take page 73.
Yes.
Page 73, they wanted to cancel the building sanction plan, and this particular revised sanction plan has been issued on 22nd to 27th of December 2018. So, your lordship, the main building sanction plan has been merged with the revised one. Now, today, your lordship, they have to challenge it. The earlier writ petition has become infructuous. They have to file afresh. That's the only contention, your lordship. I have taken, your lordship, in my affidavit in opposition. In this particular matter, your lordship, what happened? They are the tenants. They are occupying, your lordship, a very small portion of the portion in the proposed building. Now, when they are in occupation, your lordship, they file a civil suit. Those things are on the merits. Now, when we actually obtain, your lordship, the building sanction plan, they file, your lordship, an application before the Calcutta Municipal Corporation challenging my building sanction plan, that I have not taken the tenanted portion, rather I have taken the tenanted portion in the building sanction plan, and the sanction plan has been obtained. So 397 application, they filed an application under section 397 to the Calcutta Municipal Corporation to cancel my building sanction.
What is their grievance?
The grievance, your lordship, that they are the tenant.
That I understand.
And I have shown that particular tenanted portion in the building sanction plan without showing them as a tenant.
Okay.
So that's the only, that's a
So your
And
occupation has not been
Yes, sir, may I complete it, sir? Yes.
You may. So, why did you say the correct fact?
No, certainly I'll say the correct fact. What is actually in your writ petition? In the writ petition, whatever he has said, he cannot go out of that. Now, in that particular writ petition, he has also mentioned, your lordship, that he has filed a civil suit. Civil suit is still pending, and subsequently, no, there is no injunction. Civil suit is still pending. Now, what is important? Kindly see the prayer. Cancellation of the sanction plan before the Honorable High Court.
By virtue of the earlier sanction plan,
Lordship.
Permission has been granted to make any demolition or construction over the tenanted property.
Lordship, the entire premises has been demolished. New construction as per the revised sanction plan has been done. Their portion we have kept intact. Lordship, kindly take my affidavit in opposition once. This is nothing, your lordship. A small tenant is trying to stall the entire project. Nothing else.
A small tenant may have a big tenancy right.
No, he's a big tenancy right, but his occupation is very small. I'm not saying he's a. Lordship, kindly take my affidavit in opposition once.
Yes.
I have specifically mentioned that I have not touched, your lordship, their tenanted portion. Lordship, kindly take my affidavit on opposition in connection with the amendment application.
Yes, sir.
Lordship, kindly take page 6.
Yes.
Page 6, subpara G.
Yes, sir.
The original writ petition has been filed in the year 2013 for cancellation of the building plan bearing number such and such, dated 13 July 2011, along with other consequential relief. Subsequently, the said building plan has been revalidated with effect from 13 July 2016 to 12th of July 2021, and the same has been approved by the Director General Building dated 27th of December 2018. As per the application filed by the
that is during the pendency of the instant writ petition.
That is during the pendency of the writ petition. I'm not saying so. Lordship kindly sees subpara H. As per the application filed by the respondent number 6 for revalidation of the building sanction plan, the respondent municipal authorities considered the proposal under Rule 26(2)A and 26(2)B of the Kolkata Municipal Corporation Building Rules, and after considering the same, and upon proper inspection, the respondent municipal authorities have revalidated the building sanction plan and raised demand for the statutory charges for revalidation. Accordingly, the respondent number 6 has paid all the charges regarding the revalidation of the building sanction plan. I have annexed, Your Lordship, the copy.
The portion
page
of the
50.
occupied by the repair has not been demolished and kept the same as
Exactly, Your Lordship. As per the revalidated building sanction plan, the respondent number 6 has completed the entire construction and handed over the respective portion of the then existing tenant and the prospective purchaser.
I got your points.
The portion, Lordship, may I just read it, this portion. The portion occupied by the writ petitioner has not been demolished, and the respondent number 6 has kept the said portion as it was. The respondent number 6 has constructed the entire premises as per the revised building sanction plan, and therefore the writ petitioner cannot challenge the building sanction plan as per the provisions of the Kolkata Municipal Corporation and or allege any illegal construction over the premises in question. So this is, Your Lordship, and Your Lordship, moreover, if Your Lordship kindly sees, his proposed writ petition, he is taking new legal points, and Your Lordship kindly sees he has relied on a circular. Lordship, kindly take his amendment application, paragraph 5. He relied on the affidavit, Your Lordship, filed by the Kolkata Municipal Corporation in paragraph 5 at page 6 of the amendment application. And he has quoted, Your Lordship, from the affidavit. Now, Your Lordship kindly sees paragraph 6 at page 9. He has mentioned, Your Lordship, the two orders, one passed by Justice Kapoor and one passed by the Honorable Justice Aniruddha Roy. He relied on that. And where is the fresh cause of action? Your Lordship, kindly take paragraph 9. The petitioner states that it is astonishing that the affidavit of Kolkata Municipal Corporation of July 4, 2016 records that the respondent authorities approved the proposal under 26(2)A and B of the Kolkata Municipal Corporation. The respondent number 6 did not deposit the requisite fees. I have, Your Lordship, disclosed, Your Lordship, page 15 of my affidavit that I have deposited the entire fees. Now, it is astonishing that how after the finding of the KMC authorities and the respondent number 6 illegally constructed 890.315 square meter and changed the user from the residential to commercial to the extent of 1947.118 square meter was also a deviation found by the corporation. The said authorities have sanctioned a revised plan. It is also astonishing to find that despite the finding, the entire car parking has been converted into a shop area. And the case under section 400 of the Kolkata Municipal Corporation Act is also pending. Such revised plan has been sanctioned. It is also observed that the construction carried out by the respondent number 6 is illegal in nature. So, Your Lordship, now he is making, Your Lordship, the fresh cause of action or the allegation against me in connection with the revised sanction plan. Now, Your Lordship, kindly take paragraph 100, para 10, page 11. The petitioner states that it is thus unflammable as to how the Kolkata Municipal Corporation allowed or condoned deviation illegally committed by the respondent number 6 and could have proceeded to revalidate the original sanction plan as also the respondent number 6 to revise the same. That revaluation or revision of the sanction plan should not be done so for the reasons as under. Now, Lordship, various, Your Lordship, the reasons he has mentioned, those particular reasons, Your Lordship, was not there in the earlier application under section 397. Kindly say take 397 of the Kolkata Municipal Corporation.
Not now. Why should I? In the amendment application, I should not.
Yes.
What would be a submission of the corporation?
I have not given after going to the picture. right forward, it cannot be the amendment cannot be allowed because my lord, it's a straight cause of action. He has to challenge, my lord, he has to
Very
challenge by the
Take
My
that.
lord, may I kindly hears me, my lord.
Listen to my order.
Yes, my lord.
GA number 1 of 2023. This is an application for amendment of the original writ petition being WPO 977 of 2013 as filed by the writ petition. Stop. At the time of hearing, learned advocate for the writ petitioner at the very outset draws attention of this court to the prayer made in the original writ petition. Stop. It is submitted that
My lord, in appellate side, your lordship, I am fighting. My matter is 2 p.m. fixed.
Will your lordship take up the 3 p.m.
Criminal matter will be taken up now. Your matter, madam, Paul is mentioning for a consistent. What matter you are mentioning?
It is covered by your lordship judgment. It will take only 10 minutes, my lord.
Which matter?
Item number 14. It is covered by your lordship judgment, own judgment.
I believe in the meantime I will reach.
But it did not reach. It was taken up. It was scheduled at 2 p.m.
এই আজকে তো 11 নম্বরটা হয়ে গেল 12টা 12 13 14 88
If your lordship takes up till my line, my lord, kindly take it up on tomorrow at 2 p.m.
কালকে কোনো 2 PM ম্যাটার ফিক্স আছে
82 also
which one
item number 8.
Yes, lordship, so far as that matter.
then after vacation
It's for the ready.
item number 14 এর
Lordship,
কাছে
may I have a lordship?
ম্যাটার আছে
May I have a lot?
82 ফিক্স আছে কালকে কালকে হচ্ছে শুক্রবার নাকি কালকে তো যা কালকে কি হয়
His lordship, so far as item 82, we are for the respondent's lordship.
is it a very big matter or small
His lordship, may I have may I lordship have a lordship's leave to file the affidavit in opposition lordship?
not now তাহলে একটা কাজ করো তুমি 82 পরেই না এইটাকে দেবে মানে আইটেম নাম্বার 14টা
14 should be first, my lord.
No.
My lord, this is fixed at 2 p.m. Especially fixed. 82 also fixed at 2 p.m.
কালকে মামলাটায় 82টা আগে দেবে 14টাকে তারপর রাখবে 2 PM ঠিক আছে নোট করে নাও লিস্টে সেইভাবে থাকবে 2 PM ম্যাটার একটা হেডিং করো 2 PM ম্যাটার একটা হেডিং করো হিয়ারিং at 2 PM সেখানে তুমি 84টাকে আগে রাখবে তারপরে 14টাকে রাখবে got it
My lord, 14 is 10 minutes matter and your lordship is keeping it in second matter.
5 minutes 82 to
I am covered by your lordship judgment. Your lordship has already heard
Sir,
this.
my only predicament is that I'm not regular in my signature.
I know, my lord, that's
Otherwise,
why
I could have
that is
taken
impressive for ourselves also to persuade your lordship because your lordship not sitting regularly. And my lord, from 2017,
even from
the widow is suffering, my lord.
even from 2nd January, I shall again be on
In the Jalpaiguri. Yes. That's
I'll try my luck. Try my best to dispose of prior to the vacation.
Is it to be taken tomorrow?
Why not tomorrow? If time permits, I will take it up.
2 p.m. your lordship is
First, Mr. Sahar's matter will be taken up. Thereafter, if time permits, will take it up. Still, we have 2 days, no?
My lord, my matter is earlier.
No.
Your lordship is keeping it afterwards.
Yes.
I don't know. Your lordship is Mr.
Try to cooperate.
I am trying.
I don't have any inclination for anybody.
No, my lord, don't take me. I mean,
Because it has already been.
I'm just telling you, lordship, my lord, this matter I have mentioned so many times.
You should not. You should.
last question and my lord needs to fix both the matters.
এটা কি আছে?
Number 88, my lord.
My lord, I am
matter relates to my lord and
just
Who is your other side, sir?
Mr. Tarak Puran, he was here, my lord, but he
Come ready to it tomorrow.
My lord, what I am submitting, your lordship will come in taking tomorrow 2 p.m.
First, Mr. Sahar's matter, thereafter your matter.
this matter relates to our taxation.
No, দেখি কি আছে
After a long time.
Yes, after a long time, there is a difficulty. Why do you mean I am available in division bench?
Yeah, absolutely, man. I'll just
Item number 89. 88 criminal application. What type of application you have filed?
This matter relates to the relaxation of condition of appeal bail. In the year 2015.
Which for the state?
I am CBI. Against the CBI, I am applying for the CBI.
Let me see the application first. Emotions were. Where is the order of bail?
My lord, it is my annexed.
Yes. What is the offense, sir?
420, 461, 468 and 13.2 of PC Act.
You are public servant.
He was a development officer.
So you are seeking relaxation so far meeting is concerned.
Only meeting, my lord. Because for the last.
Why meeting is required?
Yeah, humbly submit. It's 2015. For the last 9 years, he is attending. I leave it before you.
Yes, it's too much.
That's why.
Take down.
91 অব্দি আমরা নট টুডে করে রাখছি, কেউ তো নেই অ্যাপেলেন্ট।
Well, probably Malad had appointed one amicus in this matter, but since it has not been served, Malad, the person who has been appointed as an amicus is not aware of it. ওটা সার্ভার লাস্ট অর্ডারটা যেটা 9/12
20th September is the last order.
9/12 20th September. Oh, 20th. Yes, Malad. Malad, probably this server. কোথায় এসেছে? তাহলে ওখানেই তো অ্যাপয়েন্টমেন্ট হয়েছে। Well, probably Malad had appointed Ms. Jonati Shah as an amicus in this matter. Last one.
Well, you're supposed to submit a report whether the appellant is still alive or not.
এটা ওই মামলাটা না যেটা Yes, Malad. Malad, I'm seeing the order. Malad, I'll get the report.
Because I didn't sit in single bench for a long time.
For a
You
long
missed
time,
the
Malad,
trap.
my junior, my class, everybody is confused today.
29 আছে এটা।
হ্যাঁ আচ্ছা আচ্ছা আমি এক্ষুনি চেক করলাম। আচ্ছা
Whether the appellant is still alive or not, that
Malad, I'll get the report. Hello, there's only one appellant. I find this is an EC Act matter. Malad, 630 liters of kerosene was recovered, seized from this person.
who is the appellant is the informant. Complainant.
Malad, it is not against acquittal, it is against conviction.
No, it is against an acquittal. It is against an acquittal.
Malad, just give me a second.
379 427.
Wrong brief দিয়েছো কি আমাকে? এটা wrong brief না? এটা essential commodities act এ দিয়েছো। Malad, I stand corrected. হ্যাঁ? brief নেই আমাদের কাছে ওটা? আরে ওটা একটা রিপোর্ট আনানো ছিল। Malad, I'll just take instructions from the last order.
বললেন এখানে এনটা কি লিখেছি বলতো, এনটা This is a case of acquittal. Only out of 7 accused persons, 1, 2, 3, 4, 5, 4, 1, 2, 3, 4 have died. 3 are alive. Administrative notice has been served upon them. They didn't appear. In the event the appellant is alive, the situation is otherwise. Otherwise, this appeal would happen. The appeal is of the year. The acquittal order is passed on. Case of 1979.
My lord, can you seize the 313? What was the age of the accused at that point of time?
A judgment of 1984.
84.
40 years back.
40 years back. At that point of time, my lord, can you seize the age of the accused?
It is a CR case. $65 years, 37 years.
37. Now, my
47.
lord, it's 37. Now,
77.
77.
I'm searching for the age of the complainant.
Age of the complainant.
Whether it is available or not.
My lord, it can only from the complaint if they have written it at that.
Or with the memo appeal to do not.
No, my lord, in the
There is
memo
no
of
affidavit,
appeal,
no.
my lord won't find the age. Another age, my lord can find in the FIR, in
the deposition area I can get.
And in the deposition. PW1 probably de facto complainant would be.
What is his name? Nimai Chand Saha. Nimai Chand Saha was 52 years in the year 1983.
100%. He must have left us.
83. Please.
My lord, I'll get all the. My lord, today I'll take down myself all the details.
একবারে এইটাও দাও বললেন এইটা উকিল বাবুকে ম্যাডামকে দাও উনি নোট করে নিন
তোমরা দুজন আছে ওইগুলোকে নোটিং করো
নেক্সট
পরের কথা আছে আমাকে খালি একটু বলে দাও
for the
Opposite party.
respondent.
Since there is no direction upon the department to serve the copy to the opposite party number 1, Purushottam Das Lahoti, there is the department is not in a position to serve us the copy of paper. So let there be a formal direction so that we can collect the paperwork from the department.
It is an appeal against
Acquittal.
Who is for respondent 4 then? What's your good name? Shahjahan Hussain and
Purushottam Das Lahoti. The opposite party number 4, and I am representing him, Shahjahan Hussain.
Oh, there is a direction is there.
But they are not giving me. I don't know why.
How could it be?
My clerk had been to the department, but the
Mr.
department.
Shahjahan Hussain and Mr. Saujida Sultana.
Sanjida Sultana, Miss Sanjida Sultana, Mrs.
They are with you?
Yes.
Respondent 4.
4.
See the order.
But the department is not giving
File
me
nothing.
direction. I don't know where.
See the order. See the order. Last line of the order. Take the server copy and go to them. In the event they do not give, make a complaint to the registrar.
I have seen that, but
Asundi.
Hello, 93 is not a DC Act.
93 file is in the department.
Oh.
The parties are not represented. Let the matter be listed in the month list of January 2025 under the same heading.
I am for the appellant. And last option, my lord,
Madam, try to collect the report, ma'am. Have you received the report?
I'm just checking. I've got the.
Because of the long gap, I believe you have blocked.
My lord, my lord, I do not know. Actually, in different cases, I had different juniors. Now, today, none of the juniors are there except my own personal juniors. And they are not aware of this, the situation. My lord, probably the department was directed to file a report. Probably, my lord. My lord, can you
Give me a second. Yes. You are for the?
and for the appellant, my lord.
But you could not contact with your client.
So, my lord, examiner submitted, my lord, 95 and 96. My lord, 95 could not be. Then, my lord, there is several exemptions. So that we have to do the law. But as on date, I know that the law is the appearance. The appellant appears.
Very good. the hotel now.
January, my lord.
Which one? Very good. You have heard the appellant. As per request made, let the matter be listed in the month list of January 2025.
After putting any date. After putting January any date.
It will come automatically in the month list of January 2025. Because I will be in Jalpaiguri till 10th. So thereafter, naturally it will be taken up. None appears.
I'm for this state.
Oh, none appears for the appellant. None advocate for the state is present. Let the matter be listed in the month list of January 2025 under the same heading. You please check whether in the meantime any report is to be
My
filed.
lord, that is what I just told them in every matter
Hey,
to
so
find out
report
the last orders and
the order the last order.
my lord, I don't know, but if the number is there, my lord, we can. She is the advocate for the appellant, my lord.
Yes.
My lord, probably then in the Wakalatnama we'll get her number.
Number is there.
My lord, we'll contact her. My
So
lord, I'll
that
just take
she
down
can
the
collect the paper.
She did not collect. My lord, we'll collect the number from here and my lord, I will inform her.
Please ask her to collect the paper.
My lord.
Otherwise, it can be taken up for hearing.
My lord. Ever after that? একটা পেপারে এই নাম্বারটা লিখে নাও
Call the next man.
তানিয়া মন্ডল এই ফোন নাম্বারটা নিয়ে বলো পেপার বুকটা কালেক্ট 99 নাম্বার আছে
It's a government appeal.
ও গভর্নমেন্ট মানে ইটস আ
State appeal.
মানে
কি আছে দেখি?
মানে it is an appeal against acquittal. My lord, it was under section 324. My lord, initially there was the my lord, conviction by the judicial magistrate. Thereafter, my lord, in the appellate court, my lord, it was an acquittal was awarded. My lord, against that state has come up. But my lord, probably in this matter also, I have to find out whether the accused persons against whom I am moving.
No, department issue administrative notice. No report is fine. Lekho. No report. sitting.
long gap, man. Otherwise things would have. এটা কত নাম্বার? I'm appealing for the state. So it's an easy act matter.
কি অর্ডার আছে? No report is submitted by the department as called for on 29/7/2024. Let the matter be listed on যেগুলো সব রিপোর্ট দেন ওগুলো নিয়ে আসে। এই দেখি ভাই একটু দেখি লাস্ট ওয়ার্ডটা। No report is received from the department
আর আছে?
দেখি কি আছে। No report is received from the report from
Before my lord writes this, I just remembered the learned public prosecutor has asked me to request your lordship can give us consent regarding the process of moving if your lordship can sit in courtroom number 226. Once the learned public prosecutor had approached before your lordship, that time your lordship had given consent. But that time we had prayed that if your lordship can sit, because that court is vacant now. My lord,
no, it is not with me, madam.
my lord, we will take all the steps, but only the learned public prosecutor
But
has
in
asked
two
me.
courts are two seats, two benches I cannot sit, sir.
No, no, my lord. Whenever my lord is sitting in this court in 551, instead of sitting in 551, if your lordship can sit in 226 courtroom.
I believe there is an objection from the bar who is practicing in the read side.
Because my lord, now that court is vacant. No, none of the judges are sitting there.
It is the version of the some of the advocates that